And Mr.
Muhammad A. Rahman University.
Muhammad A. Islam, learned counsel for the petitioner.
A. Rahman.
Mr. A. Rahman, learned counsel for the petitioner. Opinion is other respondents are there. Opinion at page 41. Then dated 30 January 2024. Notice extra copies with included, call for the records. You will fix it after 4 weeks. Prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely Abida Khatun, is apprehended, he shall not be deported out of the country without order of the court.
29 October.
Highly obliged.
Item 2.
Please, Your Lordship.
Yes.
Opinion is at page 68.
68.
Lordship.
You have to wait for bail.
Right.
Your name?
M. Rana.
M. Rana, the counsel for the petitioner. Same order. Will be considered receipt of records. Page 69, dated 13/12/2022. Passed by so. We are declaring the petitioner to your final postal 1971. In the meanwhile, if the petitioner named is last order also you write the petitioner shall cause production of certified copy of the order. Here also. In the meanwhile, if the petitioner named is apprehended, he shall not be deported out of the country without order of the court. Cause production of certified copy of the order before the Superintendent of Police Border.
Okay.
Superintendent of Police Border.
Kamrup, Lordship. Something like that.
It will be Amin down, Lordship.
Kamrup Amin now. Okay. No. Metro.
Metro, Lordship.
But Metro doesn't have Superintendent of Police. It will be
It
Deputy
will be DCP, Lordship.
Commissioner of Police. You have to amend the cause title.
Lordship, I mean,
Then this order will not be there. The petition is granted. It is noticed that the description of respondent number 5 is erroneous. Accordingly, we permit the petitioner to counsel the petition to amend the cause title in respect of respondent number 5, including the correct officer of correct description. Thereafter, let the matter be listed in the motion column.
Item 3.
Wait, please, Your Lordship. Linker certificate is at Lordship page number annexer 9, page number 52, Lordship. Sorry,
32.
51, Lordship.
51.
Linkage. This GP secretary and petitioner's brother deposed before a tribunal.
Where is the opinion?
Opinion is at page number 34, annexer 5. 24 opinion, Lordship.
34.
In page number 34.
Ms. T. Begum, learned counsel for the petitioner. Respondents are there. Opinion at page 34. Dated 20/12/2024. As by so in declaring the petitioner we have filed now post 25/3/1971 stream. Notice returnable in 4 weeks. Call for the records. Clear for bail is opposed by the standing counsel for the FT matters. Considering the projection made in the application. 10 days time to take bail of ₹5,000 to the satisfaction of.
Yes, Golpara, Lordship.
Superintendent of Police, within bracket border, Gwalpara. List of folks of the city of record.
Item 4.
May I please, your lordship? My lord, the impugned order, my lord, in page number 105, my lord, dated, my lord, 25/10/2024. The petitioner's father's name is appeared in the NRC 1950.
Also, we will get the bench.
Yes, my lord. My lord.
But Mr. T.
T. Sheikh,
Sheikh
my lord.
and counsel for the petitioner. Respondents are there. Opinion at page 105. Dated 25/10/2024, passed by so and so in so and so. Notice returnable in 4 weeks. Extra copies will be produced for the records. Prayer for bail is opposed by the understanding counsel for the every matters concerning the projection. 10 days time to take bail of rupees 5,000 to the satisfaction of
My lord, SP Dhubri, my lord,
Superintendent of Police Border, Dhubri.
my lord.
They start of links on the set of records.
5.
Highly obliged, my lord.
Yes, page
At page 22, madam.
20,
Two.
22.
I've been made a stream foreigner of person having
There's
entered.
some corrections here. What is the date?
Date is, madam, kindly come below, madam. It's 10/6/2025.
10 is 25.
Yeah, 10/6/2025. And madam, kindly see below there's a sign of the member.
Again, there is correction there also.
Below is the sign of the member, you know.
We understand, but the date below there is again correction.
We haven't done anything. That's
You don't have a type copy.
Okay, 25 only. Okay, last page.
10/6/25.
I have been made
Sir,
a stream
K.
foreigner.
Agarwal and counsel for the of the respondent for there. Opinion at page 22, dated 10/6/2025. Passed by so and so, junior, in case of so and so, reference number so and so. Declaring that it is speaking of partner opportunity in 1970 stream. Notice returnable in 4 weeks, extra copies within 2 days, court for the records. Therefore, bail is opposed by the understanding counsel for the appeal matters. Considering the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border.
Sonitpur, Lordship.
Tejpur. List of it's on the 6th of March.
6.
Much obliged.
May I please, your lordship? My lord, the impugned order is at page number 15 to
Yes.
18.
They have also joined.
My lord,
They have also joined this bench.
my lord.
Where is the opinion?
Opinion is at page number 18, my lord.
Page number
Page number
15.
18, 1/8, my lord.
18 is the
No, no.
effective part, 15
Start-
it starts, Lordship.
15.
Yes,
Okay, you'll have to wait for some time for bail.
oblige, your lord.
And Mr. A. Sattar, learned counsel for the petitioner. All the respondents are there. Opinion at page 15, dated 29/9/2023, passed by so and so in so-and-so district number so and so, thereby declaring the petitioner to be a foreigner of post 25/3/1971. Notice returnable on. Give fixed date on the returnable on so and so. Extra copies within 2 days. Call for the records. By sending a requisition to the following email address of the learned tribunal. Prayer for bail shall be considered on receipt of records. In the meantime, if the petitioner, namely Safir Quraizi, is Qureshi is apprehended, he shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police Border, North Lakhimpur, to bring the order to the notice of the said authority. List on Swenson.
31st
Oblige,
October.
your lord.
31st October.
My lord, I have joined your lordships this bench for the Indians.
No,
Oblige your lordship.
that's good.
I am from Sultanpur, UP.
But that's good, whatever we,
Yes, my lord.
whatever.
Oblige your lordship.
It's good that you have joined.
To learn, I can join everywhere, my lord. Oblige your lordship.
Item 7.
Yes. So he is normally here.
Lordship opinion is at page 72.
72.
2019 opinion, Lordship. And two brothers have been declared Indians also, but not mentioned before the tribunal.
None appears on call for the petitioner. Of all the respondents, urge so and so for the respondents. Next paragraph. Page 72. Opinion dated 13/11/2019, passed by so and so and so and so. Thereby declaring the petitioner to be a foreigner of post 25/1971 stream. It's projected in this writ petition that subsequently the brother of the petitioner has been declared to be a
NHS 16
Yeah.
and 17, Lordship.
Indian. Next, as there is an inordinate delay in assailing the Indian opinion.
May I please-
Keeping the,
Answer the mails.
keeping the issue of materiality open. Issue notice returnable on so and so. Extra copies within 2 days. Call for the records of
Second paragraph in the synopsis, Lordship. All the brothers' case records are there, Lordship. The case numbers.
the records of FT case number 81 of 2010 from the member Foreigners Tribal Second Nogao.
My lord, this petition may be disposed of.
No disposal.
Similar, my lord, order has been.
Without looking at the records, we are not declaring anything. As well as the records of synopsis paragraph 2. Seventeen. Paragraph 2 of synopsis. FT case number 1874 of the 2008 for capital A. And FT case number 373 of the 2008. Disposed of by Foreigners Tribunal within bracket second Nogao on 23/8/2010 and 5/2/2018 respectively. The requisition shall be sent to email to the following email address of the learned tribunal. The prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely so and so, is apprehended, he shall not be deported out of the country without order of the court. Yes,
Lordship, 19 or the issue of maintainability.
we have kept it open.
Yes, Lordship.
Item 8.
This PCB. Constable petition.
Lordship will find page 14, opinion. 15
is relevant, my lord. What I meant, my lord, although all the documents are produced and submitted and exhibited, but due to the wrong committed by the learned Congress Council, the
It's okay, we are.
documents
keeping
were
the
not
issue of maintainability
marked,
open.
my lord, yes.
We are keeping the issue of maintainability open. But Mr. S. Nathwar and hospital petitioner. Page 14. And so for the respondents. Page 14, opinion dated 31/7/2019. Asked by so in FT case number so, reference case number so, thereby declaring the petitioner to be a foreign of post 25/97 stream. In view of the inordinate delay in challenging the impugned opinion, keeping the issue of maintainability open, issue notice returnable on so. Extra copies within 2 days. Call for the relevant records from the concerned tribunal. The following email address of the learned tribunal. If the prayer for bail shall be considered on receipt of records. In the meantime, if the petitioner, namely so-and-so, is apprehended, she shall not be deported out of the country without order of the court. Petitioner shall cause production of certified copy of the order before the Superintendent of Police border.
11 or 9?
Yes, Superintendent of Police border,
Lordship, Barpeta.
Barpeta.
Barbata 6. Terminal number 6, Barbata.
List transfers.
11 or Agri.
Obliged.
Item 9.
May please, Your Worship.
Yes,
So the opinion is page 105.
105.
Yes, sir.
And Mr. Ainuddin, land counsel for the petitioner, and so for the respondents. Opinion dated 21/5/2025. Passed by so in case number so corresponding to our case number so. By declaring the petitioner to be a foreigner post 25 in 1971 stream. Notice returnable in 4 weeks. Call extra copies within 2 days. Call for the records. The prayer for bail is opposed by the learned standing cause for the FT matters. So considering the projection made in the writ petition. 10 days time to take bail of rupees 5,000 with the satisfaction of Superintendent of Police border,
Borpeta.
Barpeta. This one so. Police on receipt of records.
Who's the petitioner? 15 days time given.
No. We don't want to change the order. Even if I write 15
That's
days, my secretary will type 10 days.
I am obliged.
Certain things we are doing by default. Our mistake, but we are compelled to do it. Yes.
With the Lordship.
The impugned opinion, Lordship will find at page 78.
78.
These are
2019.
19, madam.
Mr. A.R. Sigdat, learned counsel for the petitioner, and so for the respondents. Then at page 78, dated 29/8/2019. Passed by so in case number so, corresponding to IMDT case number so. They were declaring the petition to be a foreigner post 25/1971 stream. Next, in view of inordinate delay in challenging the impugned opinion, keeping the issue of maintainability open. Issue notice returnable on so. Extra copies within 2 days. Call for the relevant records. Following email address of the learned tribunal. Next, the prayer for bail shall be considered on receipt of records. Next, in the meantime, if the petitioner, namely so is apprehended, he shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of certified copy of the order before the Superintendent of Police border.
My lord, Golfer.
Golpara, Lordship.
List on Swenscoe.
3110. Item 11.
My pleasure, Your Lordship. Lordship, this matter may kind of pass over for time being. Brief is not with me, Your Lordship.
Okay.
Deeply obliged.
Timing. Yes, item 12.
May I please, your lordship? Well, page 28 is the only impugned opinion, like expert even.
Page number
28, my lord.
28. Okay. Mr. K. Rahman, learned counsel for the petitioner. And so for the respondents. Page 28, ex parte opinion dated 30/4/2022. Passed by so and so. IMDT case number so and so. Thereby declaring the petitioner to be a foreigner of post 25 in 1971 stream.
It will be seen every time, time being. We can read it out.
Issue notice returnable on so and so. Expect office within 2 days or for the relevant record from the concerned tribunal. If paid for bail shall be considered on receipt of tribunal's records. So in the meantime, if the petitioner, namely so and so, is apprehended, he shall not be deported out of the country without order of the court. Next one, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police Border, Dhuri,
South Salmara Manka.
South Salman Mankachar. Okay. List from so and so.
3110.
Obliged.
Item 13.
That please, your lordship. My lord, the impugn common order at page, my lord, 36. This is a common order, my lord, expert common order. Page 36, my lord. Out of this order, my lord, 3-4 person, my lord, already, my lord.
Lordship, what to delay lordship, the delay from 18 to 25, they knew about the order. It is not that he was not aware of the order, lordship.
My lord, in
So it's a
the,
common order and 2, 3 came.
But the same mistake is here in the order.
Yes,
There's an inherent mistake.
but
can't do
even
anything
the,
about it.
even the conduct of the petitioner is wrong, lordship, coming after such a long time.
But if he's not been served with a notice, how can you find fault with the petitioner?
Lordship may remand it back, lordship.
So we passed orders where
You
uh,
can give the order.
Delhi- Delhi
Lordship,
will-
there is a order passed by lordship on these matters.
yes, yes.
pass it on. We pass this order. Yeah. The same, man. The name of the petitioner will change. Here, this Ramzan Ali,
My serial number at 27, my lord. page 43.
is page internal page 43, sorry, running page 43, serial number 27.
27.
Opinion starts at page 36. There will be correction only in respect of the description of the petition and case number. You'll come to know tomorrow. We have not, we are not saying we are disposing it off. We'll examine it because at times we find out something. You'll get to know tomorrow morning. You say it is in chambers. Make it.
Obligement.
Yeah, man.
Item
Okay.
14.
Lovely, Your Lordship. This impugned opinion is at page 59. Your Lordship, this is a matter of 2017. The delay has been explained in page number 16 in paragraph 15.
She's in the picture. No.
Which paragraph?
Paragraph 15, page 16.
Seventeen or 18.
But this can't be, this can't be a condonable ground.
Lordship may kindly look into the certified copies also. Lordship, that is the.
No, certified copies doesn't make sense. You said that, you are saying that the council said not to worry.
Yes, no, Lordship, what has
Not
happened
to
is
worry
that
means,
they could not communicate with the state council also in that period of time. This is the truth that that has been,
now after the police has started searching, now you could contact another lawyer and come to know about the order.
they tried their best, Your Lordship. They could, they had to engage the council, and immediately after engaging a council, they could take a certified
2017
copy of the
said
same, Your
after
Lordship.
8 years. 8 years we can't control.
Lordship, and this is a case where merit is there, Your Lordship. Your Lordship can find if he has established his case that he is the son of that particular person, the linkage is there, everything is there. They being the innocent person, they do not know the law outbreak of the COVID-19 also, and do not do contact with the engaged council.
2017, there was no COVID.
No, 2017, the order was being passed, and order was passed in between 17 to 18 or something, but it was not communicated to them, and they were not being informed also. Now this,
For that, we have only one suggestion to you. You get into politics, come into the assembly and then have this amendment made that in every case, the council and the party should be given a invitation letter. There should be a protocol officer sending the invitation cards to each and every home. If you can make it, well and good.
If your lordship may.
How will
kindly-
you be, how do you expect the court to communicate it to you?
The court will not communicate, the engaged
Then-
counsel would have.
Even in
communicated
this
the-
court, when we are enforcing this, when we had initially enforced this affidavits to declare the phone numbers, there was some resistance, some questions were asked.
No,
In earlier cases where we have not enforced it, still the advocates are not giving the numbers of the petitioners to, they are afraid that we will give them a message.
this
In all
will-
pending cases, we are not getting support from the learned counsel. Nobody is providing the address of the phone numbers of the litigants.
This petitioner, your lordship, they are very much illiterate, your lordship, they do not know what to do, and they have come up with this matter.
No, we are sorry, we'll have to dismiss it. This is not a good explanation. If you want, we can adjourn it, you want to.
If your lordship
make-
may kindly look into the merits of the case also, he has established everything, your lordship. He has maybe given an opportunity to establish his case before this court, your lordship.
After 8 years, they're not inclined. At best, if you want, you can adjourn the matter, you you give some better explanation, because in this explanation, we can't condone the delay of 8 years. We are not inclined to issue notice after 8 years.
Considering the merit of the case, your lordship, it may be condoned, your lordship.
No, sorry. We'll pass orders in chambers, because since we have only a half day today, we'll pass orders in chambers. We'll be dismissing it.
Your lordship may adjourn the matter, this, I will explain in a
Okay, on the, says it, they are made balance. Today. List after the ensuing puja vacation on a date to be, give a date after puja vacation. 17, sorry, it will be 17/10/2025.
Item 15.
Wait, please, your lordship.
Yes,
Lordship, this is the petitioner before your lordship. The ex parte order dated 27/2023, which is in page number 80 and annexure 26.
okay. Your name?
SRN, my name is Shohidur Rahman.
I had Mr. S. Rahman.
Oh, sorry, my lord. My name is SRN Nasir. My petitioner.
S.I.
name-
Nasir,
Oh,
okay. Mr. S.I. Nasir. Learned counsel of the petitioner. As well as so for the respondents. Page 81, opinion dated 20 July 2023. Passed by so in case number so police inquiry number so declaring the petitioner to be a foreigner post 25 to 1971. So this is ex parte opinion.
Lordship, ex parte opinion.
This is ex parte opinion dated so. Declaring the petitioner to be a foreigner post 25 to 1971 stream. Notice returnable on so extra copies within 2 days. Call for the relevant records from the learned tribunal at the following,
Notices.
by sending requisition at the following email address of the learned tribunal. The prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely so and so, is apprehended, he shall not be deported out of the country without order of the court. The petitioner shall cause production of a certified copy of the order before the Superintendent of Police border. Which place?
Golaghat SP border, Golaghat.
Golaghat. List on so and so.
Supplementary item 18.
Next it. 31 there. Deeply obliged, Lordship.
May I please? Lordship, please that Lordship, my lord, not take any action, my lord, by the respondent, my lord, particularly as number 2, 4, and 5, my lord. Incident was occurred, my lord, on 3rd August 2025, my lord. The petitioners are the, my lord, the husband and the daughter of the, my lord, victim, my lord.
Where is the FIR page number?
FIR, my lord, the page number 12, my lord. Page number 12, before the, my lord, the SSP, my lord, CID, my lord. And my lord, page 14 and my lord, 16, my lord.
People will issue notice. Sir, for that. But Mr. Alan Ingia, and the counsel for the petitioner, as well as Mr. P. Sharma, and an additional senior government advocate appearing for the respondents. Next one. The grievance of the petitioner is that his wife named in the FIR dated, FIR has been, is missing since 3/8/2025. And having failed to find her, the petitioner had lodged an FIR dated 28/2025 before the Palasbury Police Station. So however, the whereabouts of the missing wife of the petitioner could not be obtained. Most of the petitioner suspects a person named in the FIR to have allured and abducted his wife. And the phone numbers of the alleged abductor and the wife of the petitioner, as disclosed in the FIR, is switched off. Next, issue notice returnable on 14/10/2025.
Lordship, sir. 16, my lord.
Extra copies of the this habeas corpus petition, along with a soft copy thereof, be provided to the learned additional senior government advocate in course of the day. Next, the learned senior government advocate shall obtain the updated status report of the investigation on the next date of listing based on 14/10/2025.
Okay.
Extra copies and the soft copy.
I will get that order copy today.
Yes.
Now, otherwise, my lord, 14 is important.
Just before the last line, you would say that the learned senior government advocate shall send a downloaded copy of this order to the concerned authorities to bring the order to the notice of the said authorities.
19 with 20.
On the status of the petitioner's detention,
Can I just tell the court? I have in verbal instructions, Lordship, the government says since the matter is sub judice, they are unable to deport. And this petition has been filed as a habeas corpus. Now that they know the whereabouts of the petitioner, Lordship, the purpose of this petition is over. If they want to pursue or challenge the opinion, they are free to do that, since they already have visitation rights also. But in this petition, government cannot do anything because of this matter being in the court, Lordship.
Ms. Verma, we think that since it's a habeas corpus petition and the person is still under detention, we would always have jurisdiction. So either you have an updated instructions,
Yes, Lordship.
because even if you say that because if there is a detention, you'll have to tell us
Like
about it.
Lordship, like he has taken up the other matters where the habeas corpus petitions were filed, Lordship granted the visitation rights. Then Lordship has proceeded to allowed them to file the writ petition, and the Lordship has passed orders not to deport them. So Lordship may take the same stand in
You-
this petition also.
Where is your affidavit?
Page 43, madam, is filed in the 3101, madam. Page 43 it starts, madam. Page 45 is the reason, madam, cited. Some factual and madam, documentary verifications are madam, awaited.
After this vacation, because we have not really gone into it, the pleadings, because then we'll have to pass orders. And today we have limited time.
Right.
This will be rising in the first half only.
Madam,
We take it up on 14th of October,
14th, madam.
Tuesday.
Right. Madam,
Both sides are represented. Ms. A. Verma, and standing counsel for the FT matters, has submitted that this writ petition in the nature of habeas corpus was filed to ascertain the whereabouts of the husband of the petitioner. And as the same has been disclosed, all the purpose of the habeas corpus petition is served. So it is submitted that as the husband of the petitioner is a declared foreign national, the state has kept the petitioner, petitioner husband
Holding
in the
time.
holding area,
Yes,
awaiting completion of formalities for deportation or sending back. Full stop. In that view of the matter, as this bench is available only for the first half, the matter cannot be taken up for hearing today. List the matter on 14/10/2025.
madam.
21.
May please, your lordship. My lord, here, my lord, the input order at page 16. My lord,
2013.
page 16, my lord.
It's
And the order dated 19/11/2013.
Yes.
But the notice was never served to any of the persons, my lord. I have stated in paragraph 11. We could know about the case only in the June of 2025.
21. 21 or this amata to night, time.
But the order paragraph 1 says the notice was served.
My lord, that is, it is to be scrutinized, my lord. It is a false statement, my lord. Never served, my lord. Let the record me call for.
Have you annexed the copy of the service report? No.
No, we could not, my lord. Record may be called for at this stage, my lord.
Lordship, we have not been, we don't have the file with us,
It is not,
Lordship.
it is not.
Due to 2013 or other, Lordship, what delay has been explained, we need to go to that also.
We have stated in paragraph 11, my lord, that we could know about the case only on June 2025 when the BDB secretary and the local police has intimated
No,
us.
you see, in the last page of the of this writ petition, you have annexed a copy of the notice. But you have not annexed the report.
Yes, we have only annexed the notice, my lord, that is there, my lord.
But then report why?
My lord, the party has collected only the notice, my lord. It is obtained on 2/7. The notice is obtained on 2000, impugned order is also obtained on 2/7, my lord. And 19th, my lord, sorry, yes, 2/7. Let the record be called for, my lord.
Lordship.
No, because it's 2013, where we have
Yes,
15
but-
minutes, it's
My lord, when notice,
Good
no
year.
notice was served, never intimated to us, my lord.
His submission, Lordship, notice was not served. The opinion says otherwise.
And inquiry was against mother.
Understand, Mr. Sikdar, we'll have to produce the service report because 2013. And once there is an opinion, even if it is wrong by the
My lord,
tribunal,
My lord, if
That
the
will
record
have-
is called for, my lord, everything will reveal, my lord. The party has
2013
not
is
been
12
punished.
years. 12 years, we find it very difficult to entertain a repetition.
My lord, that is my, we have stated in on oath, my lord, that notice is never served. That should be examined, my lord. That is our statement on oath. If it is false, my lord, then we have no case. That we are to bear, my lord. That is our oath, my lord.
You see? But Mr. A.R. Sikdar and counsel for the petitioner as well as so and so for the respondents. Next para. In the contrary to the contents of the opinion dated 19/11/2013, which mentions that the notice upon the proceedings were duly served, the learned counsel for the petitioner, by referring to statement made in paragraph 11 of the writ petition, submits that notice was never served on the petitioners. So accordingly, to examine the said aspect, before issuance of notice on the in this writ petition, the court is inclined to examine the records of page 16, records of case number so and so, FT police reference number so and so, disposed of by opinion dated 19/11/2023 from the Foreigners Tribunal, First Morigaon. The requisition to that effect be sent by email to the following email address of the learned tribunal.
Date. Date.
List on 31/10. 31/10/25.
দর্শক খোলা নাকি? My lord, it is fixed on, my lord.
3110.
31 October.
31.
You're calling for the records.
My lord, in the meantime, some
Lordship.
protection, my lord,
And it-
not to deport, my lord, if arrested, my lord.
We are not finding it
Lordship
very.
may even make an observation if notice has been served and they have not
No, no,
appeared,
it's okay.
Lordship.
We'll take note of that.
Deep obliged.
We don't distrust Mr. Sikdar.
Item 22.
May it please, your lordship. Impugn order, lordship, page number 29, your lordship. Order dated 8/10/2024, your lordship.
29.
Yes, your lordship.
By Mr.
Mohammed A. Rahman, your lordship.
Muhammad A. Rahman, the counsel for the petitioner. And so for the respondents, page 29 is the opinion dated 8/10/2024. Passed by so and so in 50 case number so and so corresponding to D case number so and so. Thereby declaring the petitioner to be a foreigner post 25/10/1971. Notice returnable in 4 weeks, extra copies within 2 days, call for the records. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in the writ petition, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border,
Nagaon, your lordship.
Nova. List of holds and receipt of records.
Highly obliged, your lordship.
23.
May I plead the honor? Implement order dated 3/9/2024 at page number 87, Lordship.
Page number
87.
87. You are Mr.
M. Rahman.
Mr. M. Rahman and counsel for the petitioner. Page 87, opinion dated 3/9/2024, passed by so and so in so and so. Thereby declaring the petition to be a foreigner of post 25/1971 stream. Notice returnable on 31/10. Extra copies within 2 days, call for the relevant records from the concerned tribunal. Next one, the prayer for bail shall be considered on receipt of records. In the meantime, if the petitioner, namely so and so, is apprehended, he shall not be deported out of the country without order of the court. Next one, the petitioner shall cause production of certified copy of the order before the Deputy Commissioner of Police, Kamrup Metro, Guwahati. Bring the order to the notice of the said authority. List on so and so.
Deeply appreciated.
24.
May I please, your lordship?
Yes.
My lord, petitioner, my lord, is a lady, my lord, 70 years of old, my lord, and she is a, my lord, retired teacher and senior citizen, my lord. My lord, what happened, my lord, she was granted anticipatory bail, pre-arrest bail, interim pre-arrest bail, my lord, in a case, my lord. Thereafter, my lord, as per the direction of the honorable court, my lord, she appeared before the, my lord, Golaghat police station, my lord, but she was not allowed to go, my lord, and she was detained whole night and whole, my lord, day, and whole day, my lord. And on the next day evening, my lord, she was allowed, my lord. Now, my lord, police is, my lord, again threatening me, my lord, filing FIR against, my lord, one after another, my lord. So kindly, my lord, turn to page, my lord, my interim order page 32, my lord.
Where is the FIR?
My lord, FIR, my lord, page 28, my lord. Basic allegation, my lord, against one Angsuman Bora. He is my son-in-law, my lord. নেক্সট পিটিশন অংশমান করা হয় অংশমান করা হয় লিস্ট তাকে করবো নাকি কারেকশন করবো পারেন পার্টিকুলার অ্যারেস্ট করেছে সমান বড় অ্যারেস্ট করেছে দেওয়া পাশে এটা কোনো প্রবলেম নেই এটা কি করি নেক্সট পেজ সাপোর্ট নেক্সট পিটিশন টু এটা মাল্টিপ্লাই
Heard Mr. S.H. Sigrid Leonard counsel for the petitioner. And Mr. P. Sharma, an additional senior government advocate appearing for the respondents. Next panel. It is projected in this writ petition that the son-in-law of the petitioner and two others had been granted pre-arrest bail by this court by order dated 11/9/2025, passed in AB 2242 of 2025.
No, my lord, kindly, my lord. Interim order, my lord, page 32, my lord. That is another order, my lord. Interim order dated 5/9/25. Page 32.
Page
32, my lord. That was the order, my lord, where my lord, no cases were pending. That was the.
I don't know, in paragraph 9 and 10, what do you write? In paragraph 9 and 10, you say that 11/9, you got the order, you went
My
to
lord,
the
yes,
police.
another order, my lord. That is another order, my lord. In that order, it was observed that no cases are pending, apart from, my lord, Gulagat PS case number 162, in which we were granted anticipatory bail.
We are not writing history here.
My lord.
The dictation which I made, is it wrong? The dictation made so far, is it wrong?
No, my lord.
Then allow me to write the
My
order
lord, my
in the
lord.
terms I wish.
My lord, sorry, my lord, sorry.
If I am factually incorrect, then you can stop us.
Sorry, my lord.
If I am referring to paragraph 9 and 10, that means I have read and come.
My lord. Sorry, my lord, sorry.
When the petitioner and others went to the Kulaghat police station, The petitioner was not an accused, was made to sit in the police station overnight and was allowed to leave only in the evening of 12/9/2025. And accordingly, alleging illegal detention, the present writ petition has been filed under Article 226 of the Constitution of India. Next, I issue notice returnable on 14/10/2025. Extra copies of the writ petition along with the soft copy of the writ petition shall be served upon the learned senior government advocate in course of the day. Next, as illegal detention of the petitioner is being alleged. The respondent number 4 shall take note of the same and shall cause an affidavit to be filed by the officer in charge of the Golaghat police station within bracket respondent number 5 positively by the next date of listing. Next, the learned senior government advocate shall transmit download a copy of this order to the respondent number 4 to bring to the respondents, including respondent number 4 to bring the order to the notice of the said authority list on 14/10/2025.
25.
Hello. My lord, 25 is almost similar, my lord. Here, my lord, what happened, my lord? My lord, petitioner number 2 filed a, my lord, FIR before the, my lord, DGP Assam, my lord, on 27, my lord. And thereafter, on 27 at 6 p.m., my lord, a counter FIR was lodged against us, my lord. Thereafter, my lord, we approached before this honorable court and anticipatory bail was, my lord, interim PRS bail was
This will be
granted,
dismissing.
my lord.
You are the
Interim,
prime accused, you have collected money from
lord.
different sources
Hmm.
and there's an FIR against you.
yes, my lord.
So therefore, for investigation, you can be kept,
Yes,
even
my
if
lord.
you are granting
And-
PS bail.
Yes, my lord. Interim PRS bail was granted. We appeared, my lord. Thereafter, my lord, before appearing, my lord, we again, my lord, approached before this honorable court that, my lord, some other cases may be filed or may be pending against us, my lord. That order, my lord, kindly turn to pace, my lord.
I don't know, once you are a prime accused and you have collected money, misappropriated money,
Lord.
this writ petition we are dismissing.
Because, my lord, I am the.
No, you are, now you are trying to exert pressure upon the IO and the police
No, my
station.
lord, yes. My lord, one case already, my lord, has been, my lord, similar subject matter. Because, my lord, I am the, my lord, accused number 1 is the, my lord, employee of a Sangpul, of the Sangpul group, my lord. And under that Sangpul group, my lord, other companies are there, my lord. So already one case already has been registered, my lord.
You see, there are two distinct FIR against you.
My lord,
One is regarding misappropriation of the money of the company.
my lord.
Second FIR against you is by a lady who says that she has been sexually harassed
Ah.
by you.
My lord. And third affair, my lord, again, my lord, for misappropriation of money, my lord.
But now you are exerting pressure upon this is an instrument of pressurizing the police.
My lord,
We will be
but my lord,
discussing this writ petition.
because my lord, there should be one affair because after appearing, my lord,
You can ask for clubbing.
my lord, yes, my lord, I am
For
asking,
one FIR or two FIR, will you come to the division bench of the High Court in a criminal writ petition?
my lord, because my lord, after appearance, they are again, my lord, filing
That way they have
cases
100
after,
cases.
one after another, my
You'll
lord.
have to face that. You see, let us take an example.
My lord.
You and both Mr. Ahmed, you are both aggrieved by some person.
My lord.
Don't you have a fundamental right to file your FIR separately?
Because kindly see, my lord,
Please tell me, give me a straight answer.
my lord,
When I'm asking you a question, give us a straight answer.
my lord.
The question is, supposing you two are traveling together and you are assaulted by some people, do you have fundamental right to file two separate FIRs for being assaulted? No,
No, my lord.
only one FIR.
My lord. No, no, my lord. That may be filed, my lord, separate
That may
affair.
be filed.
But he,
So who will do the clubbing? What happens to the CRPC which says three offenses of a nature can be clubbed together during investigation? What happens to that provision?
but here, my lord, I am submitting, my lord. Till 11, my lord, no affair was there, my lord. After my appearance, my lord, I was detained and my lord, my lord, two affairs were registered.
What is wrong in that? What is wrong in that?
My lord, my submission is that, my lord, I am the,
For that you want to prosecute the police people?
no,
Or
my-
you'll what you call take steps in those FIRs? No, this is pressure exerting tactics. Sorry, this your mother-in-law's petition we have entertained. This is a petition we are dismissing.
then, my lord, I am withdrawing, my lord. Kindly, my lord.
Upon for Mr. S.H. Sigzad and the counsel for the petitioner, as well as Mr. P. Sharma and additional senior government advocate. Upon, after some deliberation, the Learned Counsel for the petitioner seeks to withdraw this petition. Prayer is allowed. The matter is dismissed on withdrawal.
On liberty to file appropriate petition, my lord.
For that you already have right. For
Right.
that you don't
Obliged,
have liberty.
obliged, my lord.
26.
Yes.
Lead, your lordship. It's a contested case, your lordship.
Page.
Impugn order at page 76, your lordship. Impugn order passed on
Just- just a-
5/10/2000.
Just a moment. Page number
Page number 76, your lordship.
7,
76.
6.
Operative portion is 820, 84, 20, 84,
Just a moment.
23 para, your lordship.
76. Okay, you'll have to wait for some time for bail.
Your lordship.
Her Miss
A Begum.
Mrs. A. Begum, Learned Counsel for the petitioner. And so for the respondents. Opinion dated 5/10/2023, passed by so-and-so. In FT case number so-and-so, police reference case number so-and-so. Thereby declaring the petitioner to be a foreigner of post 25 to 1971 stream. Notice extra copies within 2 days, call for the records. The prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely so-and-so is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police border,
No go.
to bring the order to the notice of the said authority. List on so-and-so. You know, fixed date 31/10. Okay. 11. Yes.
May it pleases your lordship. My lord, it's an ex parte order, lordship. An opinion is at page 31.
31.
Yes, lord.
19.
19, and petitioner has, from the order itself, it reveals that she has not received the notice, lordship.
Where is the process service report?
Process server, we did not get it, so we have stated also, lordship. That's the record may be called for, lordship.
Where is your statement?
It's paragraph 3 and paragraph 4, lordship.
3 and 4.
Certified copy is paragraph 4, lordship. And had applied for the certified copy of the case record.
Pardon me?
She, in paragraph 4, lordship.
Huh.
She was only provided with a certified copy of the order, lordship. And notice she has not received, although it was applied and the inquiry form she had received. Notice she has not received. This is the reason we could not annex along with the writ petition. And about the case, she came to know as police was searching from her co-villager recently. This is the reason she inquired.
Mrs. D. Ghosh, and also for the petitioner, as well as so for the respondents. By opinion dated 1/1/2019. Passed by, so it's page 31, passed by so FT case number so IMDT case number so. They were declaring the petitioner to be foreigner of post 1971 stream. Next, the learned counsel for the petitioner has submitted that notice of the proceedings was not served on the petitioner. By referring to statement made in paragraph 4 of the writ petition, it is submitted that the petitioner was not provided with the copy of process service report. Next paragraph, in view of the inordinate delay in issuing the impugned opinion, keeping the issue of maintainability open, issue notice returnable on so and so. Extra copies within 2 days. Call for the relevant records from the concerned, from the following email address of the concerned tribunal. Next paragraph. The prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police border,
Barpeta Lordship.
to bring the order to the notice of the said authority. List on so and so, 3110.
Briefly.
Upgraded item 17.
If the case was parted before another bench, whether
Yes. Pardon me?
Justice Majumdar was sitting with your lordship last week. Petitioner has completed their argument. I was supposed to advance my,
Oh, this was by a different bench.
yes, sir.
Okay. What size are represented? Please inform Mr. Datta.
Not, sir. He has
what's-
completed his argument already.
No, we understand, but the same
Not-
bench has to take it up.
Not, sir.
Both sides are represented. It is seen that the matter was heard in part before another bench. Accordingly, the matter stands adjourned today. List immediately after the ensuing Puja vacation. As and when they said, same bench is next available.
Much, sir.
Upgraded item 27.
Met your worship.
Yes,
Worship petitioner was earlier released by the
just.
authority pursuant to the order passed by the honorable apex court lordship. That was
just a-
certainly he was arrested
Just a moment.
on lordship in the month of May, lordship,
27.
24/5/2025. For which present interlocutor application release the petitioner and the lordship.
I to পেশ কৰিছে I copy এটা আছে দিছো
Extra. Yeah.
কিহত আমি কৰিলো
It will be released. But certainly name how to be.
she already is on bail it gets better detention
Yes.
Yes, Lordship. Taken into.
Lordship, he was released on bail pursuant to the order passed by the Honorable Supreme Court in the year two thousand twenty.
It's a common order, Lordship, that,
Lordship, during the COVID period, Lordship, that was not considered already, he was already released on bail. That's why it was not pressed. Lordship. Lordship, it is 24/5/2025.
There's no.
We are in the difficult, what you call, what you call, we have some difficulty in arriving at arriving at any conclusion. The reason is this writ petition is of 2017.
17, Lordship.
In 17, he was taken into custody in the detention camp.
Teacher,
So order of COVID was passed sometime in
19.
So for 2 years, he was still inside. And the same situation is now.
Yes.
So he's never been granted bail actually on merit.
Lordship may fix it up for hearing right on the opening, Lordship.
But now he's there from May. May means June, July, August, September, 4 months he's inside.
Lordship, from 17, the council has also not taken steps to get the matter listed, Lordship. Because council knows it better, their bail has not been granted, Lordship, and on the year 19, maybe during COVID, there was no representation. After 19, it was listed only in 24. So if the urgency was there, Lordship, when he was arrested in 17, the council ought to have get the matter listed, Lordship.
No, it came twice, but the council was absent.
Yes, that is also there, Lordship.
On 3 occasions,
The Lordship,
Council was
since
absent.
the Lordship may fix it up for hearing on the opening, Lordship, and on merit, Lordship may decide the matter. Now, creating a situation, a hurried situation to obtain bail would not be necessary, Lordship.
He was not the counsel earlier, the set of counsel, now he has appeared. L.R. Mazumdar, London Counsel for the applicant. By filing this interlocutory application, the applicant, who is the petitioner in the connected WBC 6186 of 2017, has paid for bail as he has been taken into custody on 24/5/2025 pursuant to opinion passed in FT case number 26 of 2017. That is at page 19 of the writ petition. 24/8/2017. Next paragraph. Issue notice returnable on 16/10/2025. Next paragraph, separate order has been passed in the connected writ petition for expediting the hearing. Stop in the event the matter cannot be heard on the next date of listing, the prayer made in this interlocutory application shall be considered. List on 16/10/2025. In the writ petition, you say for Mr. L.R. Mazumdar and counsel for the petitioner, as well as so and so for the respondents. The learned counsel for the petitioner has submitted that during the pendency of this writ petition, despite the petitioner having been released on bail during COVID-19 pandemic period, he has been again taken into custody on 24/5/2025. And accordingly, he has filed connected IA Civil 2889 of 2025 for bail. Next paragraph. Considering the said submissions made by the counsel for the petitioner, the court, the connected interlocutory application has already issued notice. Next paragraph. Considering the said aspect, the hearing of this matter is expedited. Next, place the matter on 16/10/2025 for. So before that you say expedited, then you say accordingly it should notice return, it should rule returnable forthwith without requiring any fresh steps to be taken. Next, this is the matter for hearing on 16/10/2025. If you can't pick up the hearing on that day, we'll consider your interim prayer.
No.
Twenty-eight with 29.
Yes. So here we have filed IA, my lordship. Actually, earlier, my lordship, we are unable to submit the bail application in time, my lordship, as the Kange's counsel was suffering from stroke, my lordship. So that is why we are unable to submit it back. Last occasion, I myself told before the court that I am unable to submit back. So a fresh bail application has been submitted. And as well as that, one of his member has been my lordship. Same tribunal has declared as Indian, my lordship.
Where is that?
I have annexed with the bail application, my lordship. Also as well the repetition criminal matter, my lordship.
Where is that?
Matter has come several times, my.
Where is that?
Page number 8, annexure 20. No, 29. 29.
Who is this? Who is this?
Rahima Khatun.
Who is
That
she?
is sister, my lordship. Kindly come to, and my name is Ainuddin, my lordship. Kindly come to page 11, my lordship. Can I read it, my lordship? Paragraph 8.
Yes.
MD Motibul Rahman, in the evidence on affidavit, stated that he knew the proceedee's father's name, Chirajuddin. My father's name is also Sirajuddin. Grandfather's name, Abdul Shoban. Grandmother's name, Amina Khatun. My grandfather's name also. Mother's name, Halima Khatun. My mother's name is Halima Khatun. He further stated that father namely were, father children namely Moinuddin, Rahima Khatun, MD Ainuddin, my lordship. My lordship may also take the.
In your written statement, have you disclosed the name? In your written statement, have you disclosed the name of
Yes, my lordship.
proceedee?
My lordship, actually, during that time, my lordship, when I in the criminal case, my lordship, I have annexed it also and disclosed it also. But in the civil case, during that time, pending, this case was.
No, no, in the proceedings before the tribunal, in your written statement, have you disclosed this name?
At that time, it was not disclosed, but fathers, mothers, everybody's name is same, my lordship. And in fact, same father, my lordship, in both the case has given Sirajuddin, my lordship. Now, here two words were Sirajuddin and Sirajuddin, my lordship. My lordship. In both the case, my lordship, he was DW2, my lordship. Kindly come to page 41, annexure 13, my lordship, in the case 1530, WPC 1534.
Page number?
WPC 1534, page 41, annexure 13. Sirajuddin, same person, in that case also, my lordship, as father kindly. And Moinut. And in the criminal petition also, my lordship, I have stated in the paragraph. At that time, no proceeding was taken against his sister, my lord. How could I know? During the written statement.
Yes, of course.
Okay, it's done. Submissions lot. This man, the petitioner, he got bail in the year 2021. He never informed the police. Only when he was arrested now, Lordship, he has approached the court and he was deported. He again came back to India, and now after coming back, the BSF has handed him over to the Assam police now, and he is lodged presently at Matia. No, Toykula, Lordship. Lordship, I have a small submission. Lordship may take it up for final hearing on reopening Lordship. Lordship. Sorry, Lord. We just, now only Lordship, we got this information today morning. That he was deported, Lordship, you can get the written instructions on this.
My
Yes,
lordship,
Lordship will do that. Lordship may consider his bail after taking up the final case for final hearing, Lordship. Because he
Lordship-
was already granted bail, he never appeared. And if Lordship looks at his conduct, Lordship 21, he was granted bail today, we are in the year 25. And this, his. Lordship, we also need time to go through the records, Lordship.
several occasions it has come, my lordship.
It has come now, but from 21, it was never listed, Lordship. After 21, he came before this court only in the form of this criminal petition.
My lord,
Yes, we will file, Lordship, but Lordship, as of today, Lordship will not grant him bail. We will file our objection. Let this case be taken up for final hearing, Lordship.
my lordship, actually, his wife is not well, my lordship. So kindly at this stage, my lordship, I have stated in paragraph 5, my lordship. I will annex medical document also if required. But later on it was given, my lordship, not in during that point of time, it was not given, my lordship. Later on it was given. But what happened, my lordship, they don't used to give any initial. Kindly come to my lordship.
Lordship, we
My
checked up the
criminal
order
case,
sheet
my
of our
lordship.
High Court after. He has re-entered, Lordship. Now he is a deported and declared foreigner.
My lordship, just for 1 minute, my lordship. I have one judgment, my lordship. Meheruddin Ali, my lordship. Can I submit it, my lordship?
Can we have the citation number?
3128 of 2017.
Just 3128 and 17. What did speak that matter?
No.
3128 of.
I will come to that, my lord. He was regularly attending the police station also. I will come to that
How,
also.
how did he appear, Lordship,
no,
when he
let
did
me
not
complete-
give?
Let me, my portion may be allowed to be.
Yeah, please.
Maybe I'm wrong, but still I want to complete. Paragraph 16, my lordship, page 9. At that point of time, the judgment was not given of his sister. When two conflicting opinions are given by the tribunal on the claim of his legacy traceable by the same person, if those opinions related to the brother relation as brothers and sisters, same case in my case also, the one favor to the either of the sibling can be applied to the other. The fact that one sibling has successfully to prove that he is an Indian, not a foreigner, does not indicate that there is a sufficient cogent material to support such claim made by the other sibling. Failure on the part of the other sibling to convince the tribunal because certain shortcoming in nature of evidence adduced, which may be attributable inability to muster the sufficient material evidence, etc. Support of proof in such proceeding being preponderance of probability. It may be certainly said that if one of the sibling brother relation has able to prove his case that he is an Indian, there cannot be any doubt that the other sibling will also be an Indian. If other sibling does not accept the proof that he is brother as otherwise. So that is my lordship, my same case, my lordship. I am able to prove that I was been that one of my sisters able to prove that he was been and detailed order has been passed, my lordship, and the same father has given the evidence. Now my lordship would kindly come. There was no fault in my part, my lordship, in the criminal case, my lordship. Page 39, Annexure F. During that time, I have not submitted, but after, later on, I was submitted. And even in after his arrest also, I myself has gone and submitted it, but no initial was given that I have submitted that document. I have that. I have given police station. This is with criminal case, WPC.
Yeah, but not in the writ petition, from the writ petition.
At that time, I was not arrested. And till 21 May 2025, I was there. I have signed the local police station. But on 24 May 2025, I was again arrested and was been my lordship sent. All my parents are Indian, my lordship. My lordship, in similar case, Honorable Supreme Court, kindly come to page 47, my lordship. Relevant portion. And that is not his fault that at that point of time, he was not able to give my lordship. But he was regularly there in the police station, he was giving back. And both the bail order was also same. Supreme Court bail order is also same, my lordship. High Court bail. Only thing is that point of time, it was not been submitted, my lordship. And suppose if I have violated the order, the I've got another judgment, my lordship.
petition for the purpose of hearing. But at this stage, we are only considering the prayer for bail. With the nature of input which is being given by Ms. Verma, although you may have a good case in the merit, we don't know, but for the time being, we are not allowing you to be released on bail.
Your Lordship, I have another.
Not saying that you don't have a case on merit. But for the purpose of bail, you will have to wait for the affidavit to be filed.
Lordship will file it immediately on reopening, Lordship. Tomorrow is the last day.
You may have a good case ultimately.
Actually, my lordship, I would not have praised my lordship. His wife is not well, my lordship, and he's only one daughter and they're living in a, if there was no holidays, my lordship. And another
We
important
understand, but
thing
we
is
can't
that,
help it.
uh,
It's in such a junction that we can't even expedite.
my
the
lordship,
matter.
several occasions tag along this case have come before this honor.
We can't help it.
And the last order, my lordship, I think we were not allowed, that order was not given that we may be allowed to meet him, my lordship.
We'll permit you to meet.
Yes,
And,
Lordship.
but
Permit you to meet
Visitation rights may be granted, Lordship.
can you,
in this IA. See the Mr. T.K. Date and counsel for the petitioner, applicant. By filing this interlocutory application, the applicant has prayed for being released from the detention center where he has been, after he has been taken into custody on 24/5/2025 and presently lodged at the, presently you are where?
AB, Poplar,
70
Okay.
Lordship.
In the holding area under 7th AP Battalion, Soraikula, Ugrajat. Next, the learned study counsel for the FT matters has submitted that she has received instructions in the matter and she prays for some time for file an affidavit to stop. It has been submitted that as per instruction received by her, the petitioner was sent back to Bangladesh. But he is re-entered into the country. Stop. Next paragraph. The learned counsel for the petitioner submitted that during the pendency of the connected writ petition, the sister of the petitioner has been declared to be not a foreigner, and therefore he submits that he would have a good an arguable point in the matter. Next paragraph, be that as it may, in view of the nature of submissions made by the learned standing counsel with the FT matters, list this interlocutory application for consideration on 14/10/2025. Stop. In this in connection with this criminal writ petition,
yes, my lordship.
can we close this matter? Since you've already filed an interlocutory application.
My lordship, also I have filed one affidavit, my lordship, kindly may look into that, my lordship also.
In this,
Criminal petition, my
petition.
lordship,
Where is that?
is there. In WBC 34/2025. And bring certain things on record, my lordship. And in this case also, my lordship, the Rahima Khatun's husband has gone along with us, my lordship. Page 59, my lordship, and page 60, my lordship.
But we have already answered that in the interlocutory application that he is now in the holding area, Saraikula. That is the statement we have recorded already. We are giving you visitation right in this criminal petition, and thereafter we close the matter. Okay, just keep it pending then. In the criminal, there's a criminal petition, writ petition 34 of 2025. There you say, but Mr. T.K. Dil and counsel for the petitioner and so for the respondents. Next, brother, the learned counsel for the petitioner, by relying on the statement made in the affidavit filed on 4/8/2025, submitted that the petitioner and her family members have not been able to meet her husband, who is the declared foreign national, in the holding center, 7th Assam Police Battalion, Saraikula, Kokrajhar. Next paragraph. The learned standing counsel for the FT matters has submitted that as per instructions received by her, the husband of the petitioner, namely Ainuddin alias Muhammad Ainuddin Ali, was sent back to Bangladesh, and thereafter he has returned back into the country, and he has been again apprehended and presently again lodged in the holding area, 7th Assam Police Battalion, Saraikula, Kokrajhar. Next, accordingly, court is inclined to permit the petitioner, namely Manjila Begum,
His wife, my lordship.
the wife of the detained foreign national, and one family member to visit the holding center at 7th Assam Police Battalion, Saraikula, Kokrajhar. And on production of a certified copy of the order, the in charge of the said holding center shall permit the petitioner and one family member to meet Ainuddin alias Muhammad Ainuddin Ali, against whom who has been declared to be a foreigner post 25/3/1971 by opinion dated 14/9/2018, passed by the learned member, Foreigners Tribunal 2nd Nagaon in FT case number 2231 of 2011. Next paragraph. List on 14/10/2025. And in the main writ petition 1534, I say, but Mr. T.K. Dil and counsel for the petitioner and so for the respondents. Next paragraph. As the records of the tribunal is received, the court is inclined to What's it at last slide? You say that the learned counsel for the petitioner has relied in the document annexed in the on the copy of opinion dated 27/12/2024, which is annexed to the IA Civil 3228 of 2025. Accordingly, the court is inclined to call for the records of this IA page 8. What? Records of FTK case number so and so corresponding to SP number so and so. There are three reference so and so. Which was decided by the opinion dated 27/12/2024 from the Ordinance Tribunal number 8, Nagaon. Stop. The requisition for the same shall be sent by the following email address of the learned tribunal. Next, list on. No, not list on. This tribunal so as to send the records on or before 14/10/2025. No, make 2025. Next paragraph. Court is inclined to issue rule returnable forthwith without requiring any fresh steps to be taken. List the matter for hearing on 14/10/2025.
My Lordship, another thing, I've also annexed that sister's document in page 40 annexure G in criminal case.
No. You don't take it like that. If you want to amend your petition and bring it on record, because we
Oh,
don't,
yes, my Lordship.
we are by way of affidavit, we are not looking at the this criminal record. This is not how we can proceed in a writ petition.
Yes, my Lordship, I will also bring on
First,
that.
one part in IA, one part in the writ petition, one part in the criminal writ petition. That's not how we hear it.
Okay, ma'am.
You'll be in difficulty.
Another thing, my Lordship, can it be allowed that Wakalatnama also, if when I
You've already filed a writ petition. You need again.
Petition is already there of 21.
in the main
His writ petition is
Oh,
already
sir,
pending.
no.
in main writ petition, my name is not there, my Lordship.
Your name is not there. That's right. You said that the first order where you said visitation right, and the in charge of this holding center shall also permit the petitioner to obtain the signature of the detained foreign national in the Wakalatnama.
Deeply.
Okay, you are right.
Item 30.
Hello, there is typographical error in order dated 29/8/2025. The order of opinion, it has been written as 22/2/2024. But it should be 21/3/2022, my lord. Only that's typographical mistake.
We did not get it. Opinion date is wrong.
Yes. It has been written as paragraph 2.
21/3. Okay. Let's see. Heard. Mr. J. Ahmed, and counsel for the applicant, and so for the respondents. Next, by filing this interlocutory application, the applicant is seeking correction of typographical error, which is kept in paragraph 2 of the order dated 29/8/2025, passed by this court in WBC 4934 of 2025. Next, it is submitted that in paragraph 2 of the said order, the date of opinion is mentioned as 22/2/2024, which ought to have been 21/3/2022. Stop. Next, as the next, in view of the typographical error, which has been pointed out, comma, the court is inclined to allow this interlocutory application by providing as follows. Number one, that in paragraph 2 of the order dated 29/8/2025, the date of opinion mentioned as 22/2/2024 shall now be read as opinion dated 21/3/2022 without requiring any other corrections to be made in the order. Next, number two, this in view of the this only don't cite one, make it same. Maybe I allow the vice so and so. Then you say that this order shall be read together with order dated 29/8/2025 passed in WBC 4934 of 2025. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police within bracket border. Bracket was Kamrup at Amingaon to bring the order to the notice of the said authority. Next para. This interrogatory application stands disposed of.
And a record of call for, my lord. Correct. Order, that record may be called for. Record of order that is mentioned. Passed in application number,
We have already called for the records.
records. Record was called for. Because well was not granted, that is why I went on.
Okay. So in the main petition, you say heard so and so for the petitioner and so and so for the respondents. Next para. By order passed on 25/9/2025 in IA Civil 3232 of 2025, the date of opinion mentioned in paragraph 2 of the order dated 29/8/2025 has been corrected to 21/3/2022. Accordingly, the registry shall send a fresh reminder, shall send a fresh requisition to the concerned tribunal for the records. Next part is provided that the learned member from a foreigners tribunal number 2, Kamrup Boko, shall read this order together with order dated 29/8/2025 passed in WBC 4934 of 2025. Next para. List as ordered earlier, list on 15/10/2025.
Item 16 for admission. Item 16.
Please see this. This name of the council mentioned here, was any proceedings drawn up against the learned council? I have a vague recollection, but I may be wrong. Not very. Not very good. I have a vague recollection, I don't remember some contempt.
My lordship, in this case, my lordship, he is no longer, I am appearing, my lordship. I have some difficulty, my lordship. I am unable to locate the file, my lordship. Abdul Motleb case, that is case, my lordship.
Yes, yes, now you will be appearing.
I will be appearing, my lordship. Kindly, I have also some of the documents I have taken, my lordship. His passport is there, father passport is some documents I'll to file one additional affidavit, my lordship. And HR Khan is not, he too is not well, he is no longer in this case. I am TK there, my lordship. I will file work.
We'll adjourn the matter then.
Yes, my lordship.
Okay, for how much time?
After,
Vacation. Uh, Mr. P.K. De, learned counsel, enters appearance on behalf of the petitioner and submits that he would require some more time to obtain the wakalatnama and to file his wakalatnama. So he also submits that certain documents could not be corrected, and therefore he craves leave of the court to file an additional affidavit to bring on record such additional document as he may be so provided. Next paragraph. The matter stands adjourned today. List on 24/10/2025. Please take note of the date, because your name will not be shown unless the wakalatnama is there. 24/10. You're fixing,
Deeply obliged.
correct? Okay.
My lordship, sorry to mention, interrupt. Can it be on 22, before 24?
22nd.
22nd or any other day before 24? Actually,
because-
what I've heard that his one land case is going on, as he is declared as foreigner. So that is why, my lordship, what happened, we have to show the order also. And can it be before 24?
Make it 22nd.
Deeply obliged.
20, okay.
Item 31 for hearing.
Impugn order starts.
You'll not
From-
be able to do it because you'll have to rise now.
Can it be on another day, my lordship?
Because there's a program in the bar. We are required to go there, 1 o'clock. You'll not be able to take up hearing now. Just say both sides are represented. Your possibility of time, the matter could not be heard today. This is the hearing on 28/10/2025. This comes. There were some mentions made. The records have not come. Please. Unlisted. Not now. No. Okay, whatever we have allowed today, make it tomorrow. Then. These few matters we have committed. Only those matters tomorrow. Those mentions which we are allowed today, listing it tomorrow then.
Deeply obliged.
Thus, upon due consideration, we are of the considered view that the petitioner has failed out to make any case for review of the order dated so and so, having found no merit in the review petition, both the review petition as well as the interlocutory application seeking delay condonation are hereby dismissed.
No, institution, Aman, I know.
That is a lordship. Lordship, the concern of the other side, I beg to mention item number 24, your lordship. In this matter, we are awaiting instruction that the matter be taken up immediately after vacation, your lordship. Item 24. 24. It's a motion matter. It's been listened twice, seeking instructions. Instruction are not completely received, your lordship. So we seek a further time, your lordship. We have taken concern of the other side, your lordship.
It can actually be disposed in the motion stage, the leave encashment part, how, whether they will give or not, that part. On reopening, you know, so.
Forest Department, the matter stands adjourned today, list again in the motion column on. When?
Immediate, your lordship.
Immediate.
After reopening.
Immediate. 22/10/2025, absolutely. So as to enable the learned standing also for the Forest Department
Forest
to obtain instructions in the meanwhile.
Hi, Lordship.
May I please, your lordship, I beg to mention item 17, lordship. It is wrongly listed, bans to matter, lordship.
17,
Yes, lordship.
your name? Your
Hmm.
name?
N. Hussain.
Mr. N. Hussain, learned counsel for the petitioner submits that this is a bench to matter. So accordingly, matter stands adjourned today, list after the list before the appropriate bench.
Lordship. Obliged, lordship.
May I please, your lordship? May I please, your lordship? Because with the consent of the other side, I beg to mention item number 33 and 34 of the supplementary list, my lord.
33, 34.
Yes, madam. Matter may be adjourned for the day. You know, here consideration of the prayers of the petitioner is on the process, my lord. We need some time, madam.
33, 34. Both sides are represented on the prayer made by Mr.
A. Gayan on behalf of P.K. Munir.
A. Gayan, learned counsel appearing on behalf of Mr. P.K. Munir, standing counsel for the Khadi and Village Industries Board. The matter stands adjourned today. list immediately after the ensuing puja petition on a date to be fixed by the registry. Much okay.
Item number one, my lord. Probably this matter become infectious. Or should we fix it after vacation? I will bring instruction from my client, my lord.
Item number one.
One, my lord.
Mr. A.K. Azad, Leonard Council, you said both sides are represented.
Lordship, in this case, item one,
Yes, one.
for the nation.
Ah.
Pension payment order already issued, Lordship. I have the instruction.
That is why.
He's saying it's an infraction.
Yes, yes.
Give it on record. Both sides are represented. Mr. A.K. Azad, Leonard Council for the petitioner submits that the matter has become infectious, but he is awaiting the instructions from the petitioner. Next para.
That is PPO and next one is ZPO, my lord.
Okay, next for the Learned Standing Council for the Accountant General of the state has submitted that has produced instructions to submit that the payment order of
Pension.
the pension payment order has already been issued way back on 4/3/2020, and payment has already been made. Most of the said instructions are kept as a part of record. Next on the prayer of the Learned Council for the petitioner list on 17/10/2022, 25. Yes.
Always.
Yes.
May it please your lordship. Lordship, I beg to mention item number 32, lordship. Here they had filed a contempt and Union of India had filed a writ. Today it is listed to intimate about the present status of the writ.
There's an IA also. What is
Yes,
this IA
lordship.
for?
I have filed for deletion of name of one of the contemner. Today it is listed for intimating the present status of the writ appeal, but after the last order, the writ appeal not yet listed. So let it be come up after vacation, lordship.
But
Here
it's
is
a
the.
contempt matter.
Yes, my lordship. I am
Unless it is a stay. Contempt can't be adjourned like that. IA is for
Deletion of name of one of the contemner.
why? On what ground?
So that he is not the person who, the direction is for one of the contemner, but he is not the person who is actually in the writ petition. He is some other person. He is not the.
See, just wait for some time.
Lordship.
After the mentions, we'll take up item 32. After this, this.
May it please your lordship.
Yes.
Lordship, I beg to mention item number 10. May this matter be taken up after vacation, your lordship. In this matter, we have to file an IA for amendment of the prayer. As due to not obtaining the signature of the client, your lordship, we could not file our IA.
10. What says represented? The Learned Council for the petitioner place for adjournment, seeking some more time to file an interlocutory application for
Amendment of prayer, your lordship.
amendment of prayer in the writ petition. Matter stands adjourned today, list after answering each of occasion on a date to be fixed by the registry.
Obliged, your lordship.
May I please your lordship? Your lordship, with consent, I beg to mention item number 2, your lordship. Your lordship, may kindly adjourn the matter for the day, your lordship. As my senior is having some difficulty today, your lordship, it may be taken after puja vacation.
It's 2024 matter. It's by there.
It is pending, lordship, since 24, lordship. The motion stays, lordship. Lordship, may kindly peruse the order at 13/5.
Just tell us what is that?
Lordship,
No, just tell us what is that? What is
lordship,
that order?
lordship has directed to petitioner to file an additional affidavit, lordship, implementing the necessary parties, lordship. That was not filed yet, lordship. The order dated 13/5/2024. Last part, lordship, I can peruse. Please, then they are taking time, Lordship.
Okay. So the counsel for the petitioner and the understanding counsel for the irrigation department are present. Next, the counsel for the petitioner, raised for an adjournment. Next, the understanding counsel for the irrigation department has pointed out that this court order dated 13/5/2024 raised a query as to whether the declaration was bad for non-joint or necessary party. And accordingly, the learned counsel for the petitioner paid for some time to impede the concerned respondents in the matter. To stop. Since then, the matter has been listed on 25/6/2024, 12/8/2024, 11/9/2024, 30/9/2024, and 21/10/2024. But the matter was adjourned on the prayer made by the learned counsel for the petitioner. Stop. The matter is adjourned on the, for the last time on the prayer made by the learned counsel for the petitioner. Stop. It is made clear that if no such application is filed by the next date of listing, the court would proceed on the basis of materials available on record. Without granting any further adjournment to the petitioner. Next para, the learned counsel for the petitioner shall send a downloaded copy of this order to the petitioner and produce an acknowledgement on the next date of listing. Next para, list on 27/10/2025.
Follow.
May I please, Your Lordship? Your Lordship, I beg to mention item number 16. Your Lordship, kindly the matter may be adjourned for the day.
16, okay. But it goes after vacation.
Yes, Lordship.
On the prayer made by the counsel for the petitioner, list in the motion column after the ensuing Puja vacation.
Bless.
Supplementary list item 22 for withdrawal.
Motion was made for item 32. If that was done.
May I please, Your Lordship?
Yes.
My lord, the petitioner has already been promoted, my lord. The matter had become infructuous. Therefore, my lord, he wants to withdraw, my lord.
Upon instructions, Mr. B. K. Das and the counsel for the petitioner submitted that the petitioner has got the
Promotion.
and therefore matter has become infructuous.
I'm for the one.
Understanding also for the irrigation department and for BTC, who's there? He is present. Accordingly, the matter stands dismissed on dismiss having not been pressed.
Order.
You want it not to be pressed or withdraw?
My lord, infructuous.
Infructuous.
Item 32.
I have to move to the.
Lordship, against the judgment, we have filed.
Okay, and the appeal is there a stay
Yes.
operating? In the appeal, is there a stay operating?
No, Lordship, delay is there. In the delay notice was issued and delay, they had filed their objection. It is pending, Lordship. So that is why the last occasion directed to intimate the status of the writ appeal, but thereafter the writ appeal not yet listed. Now,
We understand that, but you see, unless there is a stay operating, the contempt has to be you'll have to purge your contempt.
in the
But it-
contempt, I have filed my affidavit also.
We'll have to proceed in the contempt matter. We can't adjourn it like that. But then in this interlocutory application, this cannot be allowed.
Let it be pending, Lordship. I'm only praying for let the matter, whole matter be taken up after vacation, because at present, after the last two order, their writ appeal not yet listed.
No, Ms. Sharma, the problem is that you have filed an application for striking it out. And that application was filed in October 2024.
Lordship.
Because you'll have to show that on the day when the order was passed, you were not the secretary to the government of India.
No, not secretary, Lordship. It is by respondent number 2, Lordship, not by secretary. Secretary had not filed this application. Application is,
Number two is Ajay Kumar Bhatta.
no, BK Paul.
Applicant is BK Paul.
Yes.
Who is BK Paul?
BK Paul. He is the Deputy Inspector General in Frontier Headquarters and
Sector headquarters.
yes, no, he is the person is who is the applicant. He is in the Frontier Headquarters, but Sector Headquarters there is another person. But they had clubbed this BK Paul as the Sector Headquarters. That is why he is not the Deputy Inspector General and the Sector
Where
Headquarters.
is that statement in this interlocutory application?
Lordship, at paragraph 4, Lordship.
Is who's appearing for the contempt petitioner? You are there.
Mr. Jay Gogu, Your Lordship. He was in-
So if that be so, we strike it out. You'll have to impede the correct.
Main person is the respondent number 3, that is the commanded. The direction is for respondent number 3, in fact, although the specifically that is not written, but the commandant is the person who has to.
Let me allow this prayer. The interlocutory application stands allowed. If he's not the person. Have you filed your affidavit? No.
No. Matter may be adjourned for after vacation, Lordship. In the meantime.
For these things, adjournment is something which is not desired.
The contempt of name was supplied by the petitioner. Accordingly, we have varied as a contempt of Lordship.
In
But
fact,
then if he's not
But
there,
now it is
suppose
instruction.
you'll have to, you will give you liberty to impede the correct person.
Yes, yes.
Heard Ms. B. Sharma, the counsel for the applicant. As well as, I'm sorry, I forgot your name.
FBT.
If it's a AV,
On behalf of Jay Gogu.
Mr. AB,
ABT.
ABT Hawk, learned counsel appearing on behalf of Mr. J. I. Morbiya and counsel for the respondent number 1. Who's the petitioner in the connected contempt petition. Next paragraph. By filing this interlocutory application, the applicant namely, who's the applicant here?
VK Paul.
Namely VK Paul, PAL. The then inspector, the deputy inspector general, sector headquarter, SSB, Tejpur, has prayed for deletion of his name as respondent number 2 in the connected contempt petition. The stand of the applicant in paragraph 4 of the writ petition is that though he has been pleaded as respondent number 2 in the connected contempt petition, he was neither posted as sector headquarter, SSB, Tejpur, in the rank of Deputy Inspector General, nor as commandant. And it is also submitted that the office of the sector headquarter, SSB, Tejpur, has not received a copy of the judgment and order dated 14/12/2023, passed by this court in WBC 30/2015. It is the further case of the applicant that the case is related to 33rd Battalion, SSB. Next one. The specific statement of the applicant has not been denied by the respondent number 1, within bracket, the petitioner in the contempt petition. Knowledge of the appellate order dated 25/4/2013 would not make the applicant as a contender unless the the respondent is able to satisfy the court that it was an obligation on part of the applicant to comply with the directions contained in the judgment and order dated 14/12/2023, passed in WBC 30/2015. Next, in view of above, and as the petitioner as the respondent, within bracket, petitioner in the connected contempt case, which has not been able to show that the applicant was holding the office of any of the respondents in the said writ petition, being WBC 30 of 2015, comma, the period made in this application is liable to be like is accordingly allowed. The name of the applicant, namely so and so, is ordered to be struck off as respondent number 2 in the connected contempt case C 410/2024. Next para. This order shall not preclude the respondent. Don't say anything here, so just stop it. So this application stands allowed and disposed of. In the contempt petition, you write. Here it will be Mr. Hawk, the AVT Hawk, the counsel for the learned counsel appearing on behalf of Mr. J. I. Vermeer and counsel for the petitioner on record, as well as Ms. B. Sharma, the net CEC appearing for respondent number 3. Next para. Oh, it will not be in contempt, it will be in IA. But contempt petition notice has been issued.
Yes, Lordship, PDP has also been filed.
Okay. Then it's in contempt. 3. Next para, the office note dated 8/11/2024 indicates that the unserved notice on respondent number 1 has been received back with postal note, inverted commas, officer left. First of the learned counsel for the petitioner shall take note of the said office note and do the needful. Next para. In view of order passed today in connected IA Civil 3371 of 2024, the name of respondent number 2 is ordered to be struck off. Next para. The striking out of the name of respondent number 2 shall not preclude the right of the petitioner to impede the appropriate person after putting the said officer to notice compliance with the order of the court. Next, list of ensuing vacation on a date to be fixed by the registry. Number 1, you have to take steps.
Much of it.
Item 3.
Please, Lordship. My lord, we have challenged the order passed by SP Bongaigaon, that is plus 59, madam. I was the BDB secretary
Just a moment.
of Durgamari BDB. I was working in that post by virtue of court's order, madam. But the SP, without showing any reason and without issuing any notice to me,
Page number?
page 59, madam.
Yes, who's appearing for the respondents? You have filed an affidavit?
No, Lordship, we have received the instruction, Lordship, we'll be filing the affidavit.
My lord, there is interim order in my favor, but I have not been allowed to work. So, lordship may kindly observe this because this order is void.
This
ab
order
initio.
is, it goes against you, in fact.
Yes, Lordship.
After your, what you call, after your removal, there's an order of status quo.
Yes.
So you can't go back. There's no positive order
Yes,
in your
Lordship.
favor.
On that day I was working, but thereafter, after passing this order, my lord.
No, we
So-
don't know, but this is maintaining of status quo. We can't do anything. To issue notice in the matter, you file your affidavit.
Yes, Lordship.
Heard
We'll be filing by the next day.
Mr. M.U. Mahmood, learned counsel for the petitioner. He has submitted that despite the order dated 4/6/2025, directing status quo to be maintained, the petitioner has not been allowed to work as the VDP secretary of Durgamari, DURGAMARI, VDP. Next para, the Mr. Ambaracharjee, Leonard, additional senior government advocate submits that he has received instructions and will be filing an affidavit within a short time. But accordingly, court is inclined to issue notice returnable on 27/10/2025. The affidavit in opposition shall be filed at least 2 days prior to the next date of listing, with advance copy to the learned counsel for the petitioner. List on 27/10/2025.
Published.
Obliged, your lordship.
Item 4.
This case where my lord, I had filed a my lord appeal against the dismissal from service. Now, my lord, it was disposed of, my lord. My learned friend, my lord.
Lordship, yesterday, my lord, the hearing was conducted, my lord. The new commissioner and secretary has come, my lord, and accordingly, my lord, the petitioner was called yesterday to the, my lord, for the hearing, my lord. So, my lord, since the hearing has taken place yesterday, my lord, matter may be fixed, my lord, immediately after the vacation, my lord. Accordingly, the order will be also will be out.
Yes.
Yes,
you're
sir.
aware of it.
Yes,
So, my lord.
absolutely.
Mr. M. Dattar, learned counsel for the petitioner is present. So Mr. A. Fukan, learned standing counsel for the
GAD, my
GAD,
respond number 1, my
comma, respond number 1 has produced a copy of instructions dated 22/9/2025. Believe that petitioner was called for personal hearing on 24/9/2025. But 24, stop. Accordingly, it is submitted that the hearing was conducted on 24/9/2025 and the outcome is awaited. Stop. Accordingly, matter stands. The state instructions are kept for the cause of record. Next paragraph. Accordingly, the matter stands adjourned today. List on 27/10/2025.
My lord, deeply obliged.
Deeply obliged.
Item 5.
Yes.
So the matter relates to appointment on compassionate ground. Lordship. It is another case was rejected by the learned authority, Lordship, DLC, Lordship.
When did your predecessor die?
Lordship, we died on Lordship,
Executive order.
9/9/2013.
9/9/2013.
9/2013. Application made.
Principle 10 or 11, I forgot, of Achyut Ranjan Das shall not be applied to you.
Lordship, I have one more thing. Lordship, there is a new executive order, Lordship, of 30 August 2025, Lordship. There is a new executive order of 30 August 2025 by the Personnel Department, Lordship. So the issue, the prayer here is, Lordship, challenge of the memorandum of memorandum of data 18/24, and second is, Lordship, that minutes of meeting of DLC. That is the challenge in the prayer, and he have filed the case, Lordship, in the month of June 2025. So as per the executive order, his case falls under point number 2. I have sent a copy of the order to the court email, Lordship. And as per this point, Lordship, cases where which speaks into two cases where rejection of application for compensation appointment has not been set aside by any court, or cases wherein such rejection order has not been put to challenge prior to 4/4/2025 shall not be reopened unless there is a specific direction from the court. So that is the, because Lordship, prior to this thing.
No, unless I read, I won't remember.
Yes, Lordship, I understand. I have already sent into the email of the court, Lordship, just for some time. Hard copy to send it.
Okay, we'll take it up after some time. Let it.
Item 6.
Maybe. My lord, here, the domestic inquiry, whereby, my lord, the petitioner, my lord, has been proceeded with, my lord, is under challenge on 2 grounds, one, as well as the consequent inquiry report. Firstly, my lord, there is an inordinate and protracted delay, my lord, in completion of the inquiry is about more than, my lord, 10 years. show cause was, my lord, issued in 2014. And in, my lord, after repeated request, my lord, they have appointed, my lord, inquiry officer thrice. And eventually, in 2020, the inquiry officer was appointed.
It only
And
shows
in
that you
20
are very influential.
My lord,
It only shows that you are very influential.
no, my lord, your lordship will find my representations, my lord. I have repeatedly requested, my lord. One of the representation is at page 35, annexure 7. My lord, initially I was suspended. Thereafter, my lord, on my reinstatement, the inquiry did not proceed. And I, my lord, filed representations. Thereafter, my lord, the inquiry officer in 2025 submitted the inquiry report. Your lordship will find, surprisingly enough, my lord, none of the witnesses which has been cited, my lord, in the show cause has been, my lord, examined. And the documents, my lord, which are part of the show cause, my lord, none of the documents were handed over to me, which is in violation of Rule 9, my lord. And thirdly, my lord, more importantly, the inquiry officer, he indicates, my lord, 5 number of inquiries on which, my lord, he had relied on to reach the conclusion. My lord, my categorical, my lord, submission is none of the inquiry reports were submitted to me, nor, my lord, I am part of those inquiries. So essentially, here is a case, my lord, which is in flagrant violation of the rules, my lord. Assam Disciplinary Appeal Rules 1964. And secondly, my lord, it suffers from inordinate delay. Your lordship is aware, Supreme Court says that I cannot be punished twice. The delay, my lord, itself is a punishment for last 10 years. And I, my lord, do not attribute to such a delay, my lord. Now, your lordship will kindly see, inquiry, the show cause, which your lordship will find at page 20, my lord, the allegations are that certain beneficiaries, they did not receive,
Which
my lord,
page?
page 20, my lord. I was working, my lord, as a junior engineer. And certain complaints were received, my lord.
Where is the final adjudicating authority order of
But
your?
in fact, my lord, I have
Inquiry
challenged the, my lord, inquiry report,
Where is
which,
that?
yes,
Where is
which your lordship will find at page, my lord, 38, annexure 10.
38.
Yes. And these documents, my lord, documents taken into consideration, which reflects from the inquiry report, none of those documents, my lord, were, my lord, furnished to me, number one. And number two, if your lordship comes to the show cause, my lord, page 25, there are certain witnesses which are, my lord, named herein. Now, these are witnesses allegedly who, my lord, did not receive the benefit, my lord.
No, just a moment. The list
yes.
of documents are at page 24.
My lord.
1 is there, 2 is there, 3 is there.
My lord.
So 25 documents, we find that everything. is
Out
there.
of 24, my lord, yes, I have stated in para 6, my lord, if your lordship comes to paragraph 14.
Your first statement is that none of the documents were received by you. Now we find that 25 documents were received by you.
My lord, no, I have stated in paragraph 14, my lord, that out of 25, I have stated, my lord, if your lordship comes to 14, my lord, that will be clear. Para 14, my lord. That the bare perusal of the show cause statement of allegations dated 5/7/14 would go to show that the disciplinary authority relied on 25 numbers of documents and 23 numbers of witnesses to bring home the charges against the petitioner. It is categorically stated that none of the said documents relied on by the inquiry officer during the inquiry were supplied to me. Some of the documents, my lord, I have procured. Moreover, during the inquiry, none of the said 23 numbers of witnesses was examined by the inquiry officer. Those witnesses, my lord, who allegedly did not receive, my lord, the installment amount. Now, they have not been examined to come to the conclusion that they did not receive the installment amounts, my lord. As it appears from the said inquiry report dated so-and-so, the inquiry officer.
But you see, Mr. Talga, we are finding it very strange. You
Ma'am.
you got this notice in 2014.
2014, my lord, show cause notice.
Then after that, you made your written statement of defense on 23/7/2014.
Yes, 14.
You don't take that plea that none of these 25 documents were received by you.
My lord, in fact, I have stated against the charges, my lord, which has been leveled against me. Correct, my lord, that my lord, stand was not taken regarding, my lord, the witnesses or regarding the documents, my lord.
Document apart from this 25, which is relied on by in the inquiry. This inquiry report at page 38.
My lord.
Any document apart from 25 which have been relied on by the inquiry officer
My lord.
or in the disciplinary authority,
Yes. Your lordship will see, my lord, the inquiry officer says there are 5 numbers of inquiry against me, on the basis of which, my lord, it has come to reach the conclusion. Now, in respect,
That shows that
yes, lordship will kindly come to from the inquiry, my lord, officer's report. I have stated in para, my lord, 14.
no, from the order.
Yes, I'll come to that, my lord. If your lordship comes to page 40, my lord, of the inquiry report.
There.
Yes, my lord, brief of the statement recorded during personal hearing. A complaint was lodged against so-and-so regarding 47 numbers of IA beneficiaries have not received their 3 installment under AAY scheme, which according to the DO
Mr.
was,
Talukdar, in one of the replies you have filed
yes,
before the authority on receipt of your written statement of defense,
yes,
you take a plea that all these beneficiaries have been paid by you.
my lord,
You have seen that.
my lord.
So therefore, this is an admission about this first part, that this has been misappropriated. There is an admission on your part.
No, my lord,
You
what I
just-
say,
No,
that
what I'm
the-
saying is that you show us only that part where he has relied on certain matters which are extraneous to the show cause notice to you.
my lord. My lord, in fact, the allegations which are leveled against me has been disputed or controverted by me. I did not admit, my lord, anything.
There's an admission. You referred to one statement. On one statement, there is an admission.
No, my lord, if I have rightly understood, I did not, my lord, admit anything that,
You
my lord,
see,
the charges are correct.
I have to read so many things, I tend to forget or it jumbles up.
Yes.
But where is your written statement of defense?
Written statement immediately after the show cause, my lord. My written statement is at page 26, annexer 3, my lord.
Yes, page 27, last paragraph.
My lord, page 27, last para. In this connection, a proof of the payment statement is enclosed herewith for your kind observation. And as such, there was no question of insubordination as alleged that, my lord.
Page 27, last.
Well, last
The payment of first and second installment were made to II beneficiary in due
due
time.
time.
Only the last and meager installment of 9,000 had to be paid, but it was too delayed. Ultimately, I have settled all payment to the IFI beneficiaries.
Yes, my lord.
And proof of the statement is enclosed.
Yes. Here what I say, there was some delay,
No,
but I have cleared it up.
You see, I don't read it for the purpose of cross-examining you.
No, my lord.
We just read it to.
Absolutely,
make
your
myself
lordship is correct, my lord.
acquainted
My
with
lord,
the facts.
what I'm trying to say, my lord, there is a violation of the principles of natural justice because none of the witnesses are examined. Because the beneficiaries who did not allegedly receive, they have not been examined, my lord.
Mr. Talukdar,
My lord.
I don't dispute that you are a good lawyer.
No, I'm
But
sorry.
you see, you'll have to show me from that, your first statement is that the extraneous documents are relied on.
Yes.
You just show us the extraneous documents.
Yes. I'll show, my lord. And your lordship will see, this is not part of the show cause. I'll show your lordship to the inquiry report,
Just
my
show
lord.
us that and you.
Yes, correct. I'll show your lordships, my lord. If your lordship comes to page 41,
41.
yes, my lord. These are not part of the, my lord, show cause. Your lordship will come to para
Because-
2. I'll start from para 1, my lord.
Because if you make more submissions,
My lord.
then you'll draw ire of all your friends sitting behind.
Correct.
They are all big,
My lord,
calling up.
my lord, may I pray this, my lord, in this way? My lord, having regard to the paucity of time, lordship will issue notice, my lord.
No, but
Till
show
then-
us- show us
Yes,
that.
yes.
Show us that.
My lord, your lordship will come to para 2, page 41. However, from the inquiry report submitted by then PD DRDA Borbetta, wide number so-and-so, inquiry dated 14/11/23, report of the BDO Mondia Development, wide number so-and-so dated 49/17. These are all inquiry reports. It is found that a huge sum of money was retained by the JE on an unduly long period and the JE could not prove his point against the complaints raised against him beyond reasonable doubt. The DO himself admitted in his prayer petition that due to his earned leave, he could not settle the payment to the beneficiaries of so-and-so and his 30 days time to settle the payment to the beneficiaries by so-and-so. Many of the payment received so-and-so, so-and-so. Now your lordship will see these inquiry reports, which are conducted, they are behind my back. Number one, I was not part of those inquiries, my lord. And secondly, the copies of these inquiry report are not furnished to me so as to, my lord, giving me an opportunity, my lord, to defend myself. These are extraneous documents, my lord. And on the basis of these documents, the inquiry officer has reached the conclusion that, my lord, I have misappropriated the amount. And nowhere it says, my lord, that I have misappropriated. At best, it is a case of delayed payment, my lord. And the charges of misappropriation, my lord. The inquiry report and the charges are inconsistent, my lord. In para 14, I have stated, my lord.
Just a moment.
Out of the blue, my lord, this inquiry report appears. 5 numbers of inquiries.
Just a moment. Mr. S.K. Talukdar, Land Counsel for the petitioner.
Lordship, if I may, without going into the nitty-gritties, I have an objection that although this inquiry report has not culminated into the final order yet now, and it is not annexed in the writ petition. After it culminates into the final order, he has the remedy to file a statutory appeal under Rule 15. He hasn't availed that remedy.
But can you make an inquiry without compliance with the requirement of the Assam as appeal and disciplinary and appeal rules?
Lordship,
And
if
wait,
so after the inquiry has been
Which-
conducted, inquiry report has been furnished to him. And he has submitted a objection, which is at the page 44 to 46.
but if you are relying on certain materials extraneous, you are doing a disservice to the state.
Lordship, he can ventilate those in a statutory appeal under Rule 15.
No, we take note of your submissions, but we are not, we will.
And furthermore, he is relying on a particular judgment, P.V. Madhavan in para 18. Lordship, that judgment is distinguishable on facts. In this judgment, charge memo was issued in the year 2000 for the misappropriation or any allegations which arised in the year 1990. And that was the delay, because of which the court interfered and the charge memo was quashed. It is not the case of the petitioner here. The petitioner was given show cause notice at 5/7/2014. Inquiry has been conducted and inquiry report has been submitted in 29/4/2025.
11
The
years.
final order is yet to be
11 years.
11 years.
That too with relying on a extraneous document not given to him.
There is
No, if you
impunity.
say that you have the authority, special empowerment not to comply with Rule 9, you shows that document that the governor was pleased to permit you to circumvent the procedure prescribed.
My only submission is that those grounds can be taken in appeal. And if still he is aggrieved, then he can knock the doors of this writ court.
Okay. Also heard Mr.
A.K. Ghosh on behalf of Mr. K. Kumar.
Mr. A.K. Ghosh, Learned Counsel appearing on behalf of Mr. K. Kumar, Learned Additional Advocate,
Yes, sir.
Additional Advocate General for the state. Next paragraph. By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the inquiry report dated 29/4/2025. Next, the learned counsel for the petitioner has submitted that that in the said inquiry report, the disciplinary, the inquiry officer had relied on another inquiry report dated 14/11/2023 in respect of finding against charge number 2, which is not included in the list of documents taken into consideration.
Total 5 inquiry reports, my lord. At page 10, I have indicated 5 inquiry reports has been relied on,
No, it shows from here.
my lord.
Shows from the order,
My lord.
not from your statement.
My lord.
You have shown us one, we have written one.
There are references of 5 inquiry reports, my lord.
It shows that.
Page 41.
It is. 41 you stated 2013, you refer to it.
My lord.
This is just amongst others on so and so. This is not the. Next para, the learned counsel appearing on behalf of the learned advocate general, additional advocate general has submitted that the inquiry report has been submitted to the disciplinary authority. And as and when the disciplinary authority passes any order, it will be open to the petitioner to challenge the same, as well as make a consequential challenge to the inquiry report. Next one. In view of the nature of demands raised by the learned counsel, raised by the petitioner, the court is inclined to examine the matter. Accordingly, issue notice returnable on 27/10/2025. Extra copies of the petition with all enclosures be served on the learned counsel for the respondents in course of the day. Next paragraph. As an interim measure, the court is inclined to provide that the final order that may be passed by the disciplinary authority shall be subject to further orders that may be passed in this petition. Next paragraph. In other words, the pendency of this petition shall not be a bar for the disciplinary authority to dispose of the inquiry initiated against the petitioner. Next part, list on 27/10/2025. Let them pass orders, but it will be
Yes.
subject to conduct of this
Correct.
petition.
Yes. In fact, my lord, can I put one line, my lord? They will proceed with the inquiry, my lord. I am not against that, but whatever they order they pass, my lord, they will not take any action without your
No, that
lordship's
we are
leave.
not saying, but it's made subject to
My lord,
this
correct.
petition.
Obliged.
Item 7.
With this lordship, on the last occasion, the respondents were directed to obtain instruction, lordship.
We have received the instruction, we'd like to file an affidavit, your lordship. So at this, they are paid like notice because this notice has not
Just
been
now.
issued yet.
Appointment of Gaura.
Appointment of Gaur, your lord.
This is under which law?
This is,
Appointment of Forest Gaura is under which law?
lordship, I'm just looking out.
This is not under revenue regulation.
No, lordship.
In the Forest Act, do you have a provision for Gangura?
It's, this comes under your lordship, this forest village establishment and control of forest village, your lordship.
Your name?
Armethi.
Heard Ms. R. Medhi, learned counsel for the petitioner. Next, Mr.
R.
R. Gogoi, learned standing counsel for the Forest Department.
All the respondents.
FAQ for the respondents, submits that he has received instructions and takes for some time to file affidavit in the matter. Actually, question that John today. This from 24/10/2025.
Public list.
Yes, item 5.
All the pending compulsory appointment case has been streamlined, Lordship. And
So what do you, what is your prayer?
my prayer, Lordship, my prayer is that, Lordship, point number 1 dictates that all the pending compulsory appointment cases prior to 3/4/25, where OM is challenged and DLC SSC decision is there, they'll be considered by the government. They'll be placed freshly before the DLC and it will be considered. After 3/4/25, those cases, Lordship.
He was here. Just wait to pass orders in his presence.
Yes, Lordship.
Item 8.
May I please, your lordship? This is a punishment, my lord, for after disciplinary
not
proceeding,
do
my lord,
anything.
we will up to increment with cumulative effect, my lord, against which, my lord, I have filed statutory appeal that was pending on the earlier occasion, my lord. Instructions sought for.
Lordship,
Yes.
instructions I don't have at this now.
We issue notice because otherwise
My
it's
lord.
coming in motion column.
Lordship, but he may, the appeal has been preferred, that may be disposed of, and then he may push this court again.
Pardon me?
Yes,
You are not, you see, you are not doing it. People are coming to court just because you are not doing your work. Please tell us how much cost we impose on your officer who has received the appeal and not passing orders. Tell us. We start from 10,000, 10, 20, 30, 40, 50, 60. How much? Tell us. Or we say that a disciplinary action be drawn up for not passing orders.
No, Lordship, that may not be taken.
No costs.
Notice be to them.
Nowadays, my lord, how the disciplinary proceeding is conducted, your lordship will go through, my lord. It's blatant
It's okay.
violation of law. Nowadays, my lord, this is unheard.
Okay, we can't do anything about it unless we hear it finally.
Yes, my lord.
Had Mr. C. Goswami done counsel for the petitioner? A.K. Ghosh done it counsel appearing on behalf of?
Mr. K. Kumar.
Huh?
K. Kumar.
Mr.
PNLD.
K. Kumar done an additional decision. The state submit that he is yet to receive instructions. Next para. In view of the nature of challenge made in the petition, by sealing the order of punishment dated 16/5/2025, court is inclined to issue notice returnable on 27/10/2025. With extra copies of the decision to serve on the learned counsel appearing on behalf of the learned additional advocate general in course of the day. Next para. The learned counsel for the learned counsel, the learned counsel appearing on behalf of the learned additional advocate general send a downloaded copy of this order to the respondent authorities. So that their affidavit can be filed prior to the next date of listing. Next file list on 27/10/25.
Item 9.
Yes,
May I please, Lordship?
no, where is where is Mr. Goswami? Additional, you will be appearing? You are appearing?
I'm appearing, my lord.
Yes.
My lord will issue notice, will file an affidavit, my lord.
But what is your instructions? You have got it?
Yes, my lord, I have got a Sarabai's comment.
I forgot your name, Mr.
N. A. Majarbu, your lordship.
Mr. N. A. Mazhar Bhuiyan, and also for the petitioner. Also. So I've heard learned. Additional state government advocate appearing for the. For your for.
My lord,
You will appear for everyone
no, my lord, revenue,
except revenue.
my friend is.
Revenue is.
Number 3, 4, and 5.
Sir. 3, 4, and 5. Apart from that, 1 to 9.
Yes, my
I
lord,
have Mr. Dhar.
I will appeal.
3, 4, and 5 by Mr. J. Hendick, standing also for the Revenue and Disaster Management Department. Next, brother. But tell us how your reputation would be maintainable.
Lordship,
Tell us how your reputation would be maintainable. What is your fundamental right?
Lordship,
It is violated.
the petitioner's father died, Lordship, in harness, and thereafter her name has been recommended by both DLC and SLC, Lordship. Thereafter, even the deputy commissioner has submitted a proposal for her appointment, Lordship. Thereafter, suddenly after 2022, Lordship, that nothing has been acted upon on it, Lordship. So now, Lordship, the petitioner is
But
suffering from
this
acute
is
financial.
settled, there is a government scheme, can operate at any time, can stop at any time.
Lordship,
How is your fundamental right violated?
Lordship is the person.
Operate on compassionate scheme doesn't violate any fundamental law, fundamental right.
Yes, Lordship. But the thing is, Lordship, before 2017, Lordship, those who died in harness, Lordship, there are many cases where compassionate appointment has been given to the beneficiaries, Lordship. So in that regard, the petitioner also applied, Lordship, and thereafter her case has been justified by the department as
No,
well.
no,
Lordship.
just now, you see, Mr. C.K.S. Barwa has given us that OM. If you say that your case be considered under that,
Yes,
then we close the matter. But if you insist on the quashing of the office memorandum,
Lordship, there are judgment of coordinates bench of this honorable court also, Lordship, where it has been Lordship. Lordship, it is annexed in the petition itself, Lordship.
yes, 4086, that one, page 58.
Yes, Lordship.
Yes, 58, this order, you see, doesn't take note of you see this, what do you call? What is that judgment?
State of West Bengal versus Devotee. Lordship, Abdul Kadir Bakshi versus.
Not this, before that. It
Was it
says
already
that
on my lord?
it is only a scheme. No fundamental right gets violated.
Lordship, may kindly peruse. The order starts at Lordship page
Yes,
50.
we've seen that.
And thereafter also, Lordship, coordinate bench of this honorable court in many cases, Lordship, directed the authorities to consider the cases without considering the office memorandum, Lordship, in the light of this judgment, Lordship.
My lord, now here the thing is that now the biggest hurdle is that, my lord, we have done away with the compulsion appointment.
Scheme has been withdrawn.
Withdrawn by-
benefit you
by-
get Before the appointment is made, you don't get the benefit.
September 2024, my lord. A bunch of writ petition was filed challenging that state, my lord, in the challenges, my lord, has given a, my lord, a consent that, okay, we will only examine this matters. So the honorable court, without interfering with the OM, my
You
lord,
see, here also in this page 65, you have been, matter has been remanded back to the SLC for first consideration.
that's not true.
That is the only leave you can get. That is under the new notification which has come. If you insist for the challenge has to be negated, but you will get the order at page 65. It can be remanded back to the government to take a decision. That is within the scope of that OM.
Lordship. Lordship, they may file, Lordship, let them file an affidavit, Lordship.
That was part two.
So whatever I am submitting, I will be filing those things in the affidavit.
It's okay.
Lordship.
Yes, then.
Before puja, I don't want to
What did you say?
discourage my friend.
Last line.
Okay, sir.
Yes, sir. Learned additional senior government resident submitted, he has received instructions and will be filing an affidavit in a short time. What is the matters from this ground today? This is in motion column. Review the nature of challenge made in this report. Court is inclined to issue the returnable on 29/10/2025. The affidavit by the state shall be filed to this prior to the Ministry of District based on 29/10/2025.
Lordship, can it be on the second week of November, Lordship? I will be not available, Lordship.
Second week.
Second week of November, after 5th of November, Lordship.
Okay. 7th of November.
Obliged, Lordship. High levels.
Item 11.
Yes.
Lordship, petitioner was ordered to be retired from service, Lordship, on the ground that he is not suitable. Impugned order, Lordship, kindly have a look at operative portion of the order at page 36.
Page
36, Lordship. Operative portion of the order starts from page, Lordship, 34. May I read?
Yes.
Lordship, thereafter petitioner preferred an appeal, Lordship, statutory appeal. That is also rejected, and upon the order passed by the respondent, Lordship. That is at order at Lordship Annexure 9. Page 41 onward, Lordship. His appeal also rejected. Lordship, at this stage, notice may go, Lordship. And Lordship, what happened in this case? One Monty Das made a complaint that he marries.
See, unsuitability is something which is required for the uniform force. Okay, we'll issue notice.
Lordship.
For Mr. Raj Mazumdar, because the nature of allegation against you, you will be, doesn't appear to be anything wrong. But Mr. L.R. Mazumdar and counsel for the petitioner and Ms. E. Sharma, the AP, the CCC for the respondents. Next one. the order dated 1/2/2025 declaring the petitioner to be no longer suitable for service, and the appellate order dated 15/7/2025 affirming the same are upheld by filing this resolution under Article 226 of the Constitution of India. Issue notice returnable on 30/10/2025. Requisite extra copies of the resolution is served on the government CGC in course of the day. Next para list on 30/10/2025. There's a judgment in the last part of 2024 by the Supreme Court saying that there should be limited exercise of power under 226 in such cases when interfering with members of the armed forces. Just find out if you can.
Obliged.
Okay, your other matter,
Lordship.
Item 5.
Five.
it says it will be under this memorandum.
There is a order passed by this honorable coordinate bench of this honorable court. Lordship.
Pass.
Yes, sir. Madam.
Consider very this thing.
The same thing,
I have not seen the order, Lordship. This.
this order which is referred here in your this executive order.
Huh.
324, same thing.
Then otherwise it is, that's been mentioned in point number 1. But he has opened his case, like he has filed his case in the month of June. So accordingly, if we say point number 2 is, will attract him.
But this LR, you then close this matter.
Yes, Lordship.
It will be covered by this OM and this judgment. But Mr. LR Mazumdar and counsel for the petitioner, as well as Mr. C.K.S. Barwal and committed to get appearing for the respondent. Next one. The learned counsel for the petitioner as well as the learned government advocate have stated that the case of petitioner would be covered by an executive order bearing number this one, AVP. Dated 38/2025, which is on the basis of order dated 3/4/2025 passed by this court in WPC 342 of 2025. Give a dash. Abdul ABDUL Kadir KADIR Bokshi BOKSHI versus State of Assam and others. Full stop. In view of above, without going to the facts of this case, the present writ petition stands disposed of in terms of directions contained in the said order dated 3/4/2025, passed in WBC 3/42 of 2025. Next paragraph, the petitioner shall produce a certified copy of the order before
Before the department.
Lordship, it is DLC Kachas.
Direct DLC.
No,
is not
DLC
there.
will not do anything now.
PHC department. also.
Executive.
No,
Executive.
executive engineer, PHC. PHC.
Respond number 6.
Respond number 6, before the executive engineer within bracket PHE, bracket close Silchar, division number Roman 2, Silchar, so that the matter can be processed in accordance with the
Executive orders.
said executive order dated 30/8/2025, referred above. Next, the copy of the said executive order and the downloaded copy of order passed in WBC 3/42 of 2025 is retained on record.
All right.
Item 12.
Yes, Your Lordship. My lord, matter pertains to praying for direction to release date come retirement benefit, my lord, for the service rendered by
2023, she died. What is your admissible dues?
Yes, my
On
lord,
account of?
date come retirement benefit, my lord.
Yes, we should notice here.
Lordship.
Heard Mr.
A Gohai.
A. Gohai, learned counsel for the petitioner. The case of the petitioner is that her mother-in-law, late Ramkali Basfore, RAMKALI BASFORE, was appointed as a part-time grade 4 sweeper on 5/8/1983, and her service was regularized by an order dated 22/11/2019, issued by the Superintendent of Police, Gwalpara. So however, she died on harness on 9/10/2023. Stop. It is alleged that the authorities have not released the admissible area salaries to her deceased mother-in-law during her lifetime, and the state respondents have not released the death cum retirement gratuity from a group insurance savings, from a provident fund, from a leave encashment benefit, which was accrued to her deceased mother-in-law. So accordingly, this writ petition. The issue notice returnable on 3/11/2025. We visit extra copies of the writ petition, which have only done it.
I'm appearing on behalf of RK Talukdar for responding to.
RK Talukdar. Yes, add Mr. Miss
RR Saikya.
R.
Saikya.
Saikya. And counsel appearing on behalf of Mr. RK Talukdar. Done it.
Come in general respond.
Counsel for respondent number. Your number?
Mr. number 3.
Number 3. For others, Mr.
Lordship, I am appearing for responder 1, 4, 5, 6, and 7.
1, 4, 5, 6, and 7. So, see case by one. I appear for R2, finance. Mr. R. Bokuzan, is the standing person for Finance Department, R2. Accordingly, issue notice, returnable on extra copies as the learned government advocate and then counsel for respondent was 2 and 3 have entered appearance, requisite extra copies of the repetition be served on them in course of the day. Next para, the pendency of the repetition shall not be a bar for the concerned respondent authorities to calculate the area benefit which would have accrued to. What is the name of your mother-in-law?
Ramkoli Baspur.
Ramkali Baspur, the mother-in-law of the petitioner during her lifetime, and to release the DC RG, GIS, PF, and leave encashment benefit for the petitioner if he is found entitled to the same. Next para, list on 3/11/2025. This, he has to produce certified copy before any authority for this.
Lordship, let me, at this stage, no, Lordship. Let me guess whatever correspondent.
Okay.
The parties is made particular.
13.
May I assist, Lord?
Yes.
Sir, matter pertains to non-release of my compassionate family pension. This case, my lord.
And Mr. R. Goel, that is.
Yes, it is.
Account
Secure on behalf of the architect. Mr. R. Bokuzari, and standing for Finance Department. R1 minus. Respondable one. Non-release of the compassionate family pension is agitated in this writ petition, filed under Article 326 of the Constitution of India. Issue notice returnable on 31/10/2025. Extra copies of the writ petition be served on the Garnet State and the Department Council in the course of the day. Next, the pendency of this writ petition shall not be a bar for the respondent numbers 2 and 3 to calculate the entitlement of the petitioner and for his compassionate family pension if found due to her. Response.
14.
May I please, your lord?
Yes.
My lord, this matter pertains to pension matter.
Pension.
Pension. My father demised in the year 2010 itself, that time.
Family pension.
Yes, your lord.
Say what else last. Mr.
My name is A. Nazari.
Mr. A. Nazari, land counsel for the petitioner. The respondents are presented.
I put 2 and 4, lordship.
Ms. S. Sharma, and it's standing also by department representing respondent is 2 and
4.
4. 2, 4 and 5 also then. This is
Dima Hassan, yes. The separate studies.
Your call?
1 and 3.
And Mr. D. Burman, let government advocate take corresponding to 1 and 3, and Mr. S. Committee, standing also corresponding to 6. Who is for this Dima Hassan?
It's RM Das, in the standing committee.
Sir RM Das, and standing also for the NCL's autonomous council. Representing respondent of 5. Next para. Let's say non-payment of family pension, same money. Let's just say 31/10/25.
The name of standing also demands of maybe shown.
The registry shall reflect the name of SC, NC, HAC be reflected in the cost.
now
of this plan.
Dimas.
Is the name changed?
Yes, and he was to Dimas.
Because it was NC,
Earlier it was.
then DH, the demands of was concept DHAC. This is the next. Miss, Mrs. Sharma, before you leave, please come into the chamber. I have something to tell you.
Lordship.
Item 15.
Has the PS Deca spoken to you now?
No, well,
Okay. Then when I rise, please meet for.
yes, I'm here.
My lord, I have a prayer, my lord. I have some confusion in my statement, my lord. Just now I have seen, may I pray, my lord, it may come after vacation.
Which one? Item 15?
Yes, my lord.
Okay. On the prayer made by Mr. Asbara and counsel for the petitioner, the matter stands adjourned today. Miss M. Razaji, government advocate for the respondents is present. Rest of the revision on in the motion.
Deeply obliged, Lord.
Yes, 23.
Supplementary item 23.
On behalf of Mr. Jai Bogi, I am appearing between the provision and pension of the petitioner.
Yes.
Regarding
Used to make payment, Mr. Mehdi.
We are not dealing with my lord. Only the pensions paper, my lord, discipline, it was returned back, my lord.
No, responsible who is responsible who? Principal accounting. Oh, no, you will not pay it to the department.
Yes,
So you will pay it to the department.
But they send, my lord, the food, pension, my lord, the pension papers, my lord. We have returned it, my lord, on 24th September, no, some. So for the pension is there. Now, this petition is for provisional pension. Department proceeding is there, my lord, so provisional pension claim.
The provisional pension will be
Released by the department.
will be examined by respondent number 2 secretary, or it will be by respondent number 1.
It will, done by the secretary, Lord. Respond number 2. As per,
Respondent number 2.
yes, sir, Lordship. Let me take the instruction, respond number 2, what is
Mr.
stated?
ABT Hawk, learned past the petitioner, as well as Mr. SK Mehdi, learned standing us for the respondent number 4.
7 to 9.
Mr. R. Bogay, learned standing us for the excise department, representing respondent numbers 1, 2, 5, and 6.
1, 2, 5, and 6.
And Mr. R. Bogay, learned standing us for the finance department, representing respondent numbers 3 and 7. That's better.
incorporated for tomorrow. Both of the
The petitioner claims a direction upon the respondent authorities for releasing the admissible pensionary benefit to the petitioner. It also claims non-payment of the provisional pension even after expiring a few years from the date of superannuation. With effect from 31/7/2023. Next para. The learned standing counsel for the accountant general has submitted that by an order dated 22/9/2025, the respondent four was directed to release the provisional pension. First of all, he submits that the provisional pension is not paid by the principal accountant general, but the same is processed and paid by the concerned department, which is the excise department. Next paragraph. Be that as it may, it shall notice returnable on 31/10/2025. Requisite extra copies of the requisition will serve on this island. State and Department to Council in course of the day. Sir, the submissions of Mr. Mehdi, you also add. Mr. Moreover, he has also produced a copy of letter dated 24/9/2025. By the said letter, the pension case of the petitioner has been returned to the Superintendent of Excise from Morigao for the causes as reflected therein. Next paragraph. Let a copy of the said letter be also provided to the Land Council for the petitioner.
It's received by the petitioner. It is received by.
Oh, she has received it.
Yes, ma'am.
Okay, and it submits that the copy of the same is already served on the petitioner of 19/9/2025. Notice extra provision for today. The respondent number two, I, the secretary, the government of Assam, finance, excise department is put to notice to ensure that the payment of the pending finalization of the pension of the petitioner, the said excise department shall take steps for release of provisional pension for the petitioner. And steps taken to that effect shall be informed to the court by way of written instructions to the learned standing counsel for the excise department. Next paragraph, list on. Now, just say to stop. In other words, the pendency of this repetition shall not be a bar for the respondent to process and release the payment of provisional pension to the petitioner. Next paragraph, list on 31/10/2025. Next paragraph, the petitioner shall produce before that you say, the petitioner shall produce a certified copy of the order before the respondent to the order to the also.
All right.
This depends. The last letter is made a part of it.
25.
Wait, please. Yes. In this petition, I challenge a order of appeal. The petitioner was dismissed from service on 28/9/2024. Thereafter, I lodged an appeal. The order of appeal has come.
So DP Foran and Council petitioner. He's appealing for the respondents. It's better than you're appealing for all. Same better than the additional senior government advocate appealing for all the respondents. Next paragraph. I think this is repetition under Article 226 of the Constitution of India. National has paid for crashing of the order dated 28/9/2024.
And 9/7/2025. Page 14 prayer.
28-9, where is that?
In the. It's an order rejecting my appeal, 9/7/2025. It is in page 50.
No, 28-9/2024.
Yes, Lordship, that is on page 40.
We are not have, don't have the page 40 lordship here. Up to page 39 only it is here.
Okay.
No, we have 54. We have page 55. You don't have that.
Copy, dear.
25, I have lordship.
Copy you
No,
have given.
55.
No, that copy I am requiring, but it's up to page 39 only. I am having, this is a stitched copy. Up to page 39 only.
This is, I think this is not the copy. From the first. Okay, I'll leave. Requisite extra copies, Lordship, with this.
Requisite extra copy is something else, because I prepared my submission after this page on the lordship of.
Question of the appeal order dated 28-9/2024. Within bracket annexure F. Being aside of the department proceeding issued by show cause notice dated 12/6/2024. Notice dated 9/6/2025 to vacate the government quarter. And for setting aside the appellate order dated 9/7/2025 passed by the appellate order. Issue notice returnable on 31/10/2025. Requisite extra copies of the repetition with all enclosures be provided to the runner. Additional senior government advocate in touch of the day. You have been discharged from service.
Yes.
Okay, then we are not inclined to give any protection for
Yes, Lordship.
prayer number 3.
Yes. Lordship, prayer number.
Prayer number 3, we are rejecting it outright.
Yes, Lordship, we have already, in the meantime, we have vacated.
You vacated.
Vacated therefore.
Okay. We have said issue notice on the prayers, number 1, 2, and 4. Return of the suspect for purposes of the regulation, except from the Singaporean Film Council. Next. The learned counsel for the petitioner submitted that as per instructions received by him. During the, in the meantime, the petitioner has already vacated the government quarter. For which prayer number 3 has been made. List on 31/10/25.
Lordship, I'll provide extra copy.
26.
My lord, yes, my lord, sometime you can get to take instance. My lord, already, I think, not talk with them, my lord. Meta will come after vacation, madam. Yeah, I'll get from those, I'll get from those.
What, 15 go, you only know Monday.
15 or 13, so different to go.
Certificate of practice of central notary. Okay. Mr. B. Chakravarti and counsel for the petitioner.
17.
As well as SK maybe, then CBC appearing for the respondents. Next. The petitioners approach this court for a direction upon the respondent authorities to issue certificate of practice of central notary public for the state of Assam to the petitioner by correcting his date of birth. Extension notice returnable on 29/10/2025. 29. Receive extra copies of the resolution. This have been done. It's simple. Extra copies. The pendency of this resolution shall not be a bar for the concern responded. Examine the case of the petitioner and do the need proof. Please take a look. Good with the data. Next page is not 29/10/25.
27.
May it please your lordship. Petitioner before lordship is a my lord retired my lord government servant my lord as a financial advisor my lord. He's my lord. He challenged my lord two order my lord. Pay 1/19/2025 and 4/9/2025. Annexer 21 page 82 my lord. Last page my lord. Page 82. The government of Assam is pleased. Your lordship got it my lord. Governor of Assam is pleased to appoint so and so secretary government of the as inquiry officer under Rule 94. So Assam Disciplinary Rule inquiry and presenting officer and another my lord.
But this order of the, but this notification cannot be quashed.
Yes, my lord. And my lord, another words in by page 78. This order has been passed by the authority for inspection of documents, my lord. This is, my lord, the beyond the jurisdiction, my lord, already timeline prescribed by this honorable court, my lord. Your lordship go to the court, honorable court order, my lord. Page 66, my lord, annexer 16, my lord. Due to delay of the departmental proceeding, I come before the honorable court has specified by direction, my lord. Page 66, an operative portion, my lord. Page 74, my lord. Your lordship got it, page 74, my lord. They cannot pass the order beyond, my lord. Already time limit was page 74, your lordship.
No, but here the last line is such a measure would however be subject to outcome of the departmental proceeding.
Yes, my lord. Please make kindly say page 74, my lord.
Yes, we are.
May I read, my lord? Para 14.
That's what we are reading.
Yes, my lord. Space. This writ petition is therefore being disposed of by directing the respondent to conduct and conclude the departmental proceeding within a period of 4 months. That is 120 days from the date of receipt of a certified copy of this order. Facilitating the above, the concerned department is to transmit the relevant record as expeditiously as possible. It is made clear that if for any reason whatsoever the departmental proceeding is not concluded within the timeline provided by this order, the respondent shall finalize the pension of the petitioner within 4 weeks thereafter and release all his outstanding dues, my lord.
And don't read 2 lines which I have read.
Yes. Such a measure would, however, be subject to the outcome of the judicial proceeding or departmental proceeding, my lord.
That will go on. We can't quench that. That's why we said, you see, you read the entire thing and we
Yes,
said.
my
that
lord,
it's 2 lines.
no, my lord. The honorable court specified the 120 days from the date of receipt of a certificate to conclude the departmental proceedings. If they did not do it, that within timeline 120 days, thereafter 4 weeks is given to give the pension, my lord. And
Yes.
thereafter, my lord, I submitted, my lord.
But still this departmental proceeding would go on. That's
No,
why we
my
said it can't be
cannot,
quashed.
my lord. They without my lord filing leave petition before the honorable, I'm contempt proceeding, my lord, contempt, my lord. Thereafter, I submitted the order on 7/3/2025, page 75, annexer 17, my lord.
We don't know that amounts to interpretation of the order.
Yes, definitely, my lord. Then,
This
my
order-
lord,
this
who-
order
who-
says-
who-
This order says.
they sitting over the matter, my lord, without
be-
extension, my lord. How, my lord? Thereafter, my lord, page 76. This is the contempt petition after completion.
I don't know this.
My lord,
lines-
that order is passed only, but suppose criminal case is pending. Criminal case is any is there,
Such
my
a
lord.
measure would, however, be subject to the outcome of the departmental of the judicial proceeding.
Yes, my lord.
Departmental proceeding can't be quashed.
No, my humble understanding is that, my lord, the honorable court directly given specifically mentioned 120 days. Why 120 days is necessary given? They complete the departmental proceeding within 120 days. And thereafter, if they did not conclude the departmental proceeding 120 days, Thereafter, they are given the 4 weeks to allow me to pension and other service benefit. And immediately thereafter, I file a application or certified copy on 7/3/2025. And thereafter, after not giving my pension and other benefit, and immediately I file a contempt petition and contempt notice was issued on 29/8/2025. After receiving of the contempt, my lord, they issued an order, you come to inspect the documents. Well, how without, my lord, they have to file a extension petition, my lord. That departmental proceeding subject to, that means, my lord, my limited, my lord, knowledge, my lord, there is a judicial possible because of he was arrested. That was not any proceeding, any criminal case till today. Well, if there is given that the outcome, suppose I am given the all benefit, pensionary, that will be again they keep, my lord, doing that, my lord. But my understanding is that 120 days is specifically mentioned by this honorable court to complete the departmental proceeding within 120 days timeline, my lord. And 120 days after completion of the 120, if you did not do it, they are given 4 weeks. And after 4 weeks, they did not allow me to pensionary and other service benefit, and immediately came before the honorable court. And honorable court issued notice, the contempt notice, my lord. After receiving the contempt notice, they issued this order letter, my lord, page 78, my lord. And 78th inspection document, I given a letter, my lord. I forwarded a letter. I am stating that question does not arise because of that stage is over, my lord. 4 weeks, 120 days over, thereafter 4 weeks is over. How without, my lord, extension, without appeal, this is become, my lord, final, my lord. Because of that, your lordship says that, but subject to that is another issue, my lord. They suppose I am given the honorable department is given the all pensionary benefit. Thereafter, suppose they within 120 days, I have, my lord, given the punishment, my lord. That is a different issue. That is, they did not do it. They're sitting over the matter. They given even not given any extension petition, my lord. They cannot, my lord. My lord, they cannot now, my lord, open this, my lord, inspection of the document as well as the inquiry officer.
Does this order at page 74
My lord,
say that if in 120 days the disciplinary proceeding is not completed,
yes,
it would stand dropped?
yes, then drop and thereafter use.
Where is that? Where is that?
Yes,
First,
the writ petition is therefore being disposed of by directing the respondent to conduct and conclude the departmental proceeding within a period of 4 months, that is, i.e. 120 days, from the date of receipt of a certified copy of this order, facilitating the above, the concerned department to transmit the relevant records as expeditiously as possible. It is made clear that if for any reason whatsoever, the departmental proceeding is not concluded within timeline provided by this specific order, my lord. They did not do it. They're sitting over the matter, my lord.
I have a very simple question. You see,
My lord.
for a few days, I have not been dealing with this service matter. I'm just asking simply, can we read this order that the proceedings initiated would or shall not be initiated or proceeding initiated shall stand dropped? That is the only understanding I want.
My earlier writ petition is fair is that they due to delay the more than 10 years, they have not doing that because of the stage in, my lord, your lordship go to it, my lord.
Mr. Bora,
My lord,
I don't have personal knowledge of what you pleaded there.
my lord.
I was just asking you, I'm opening up page 74 and I'm merely asking you, would this order mean that the proceeding would stand dropped? It's a simple question I'm asking.
My lord, they have given the liberty to the department to complete the departmental proceedings. It's a specific direction, my lord.
That is an interpretation. I'm just asking a very plain and simple question. It's
My
not a
lord.
very difficult question.
My lord.
Will this mean that the proceeding will stand dropped? Or there is a bar of initiating a proceeding after 120 days? Can we read that?
That means such measure would, however, be subject to the outcome of the departmental judicial proceeding, my lord. My lord, because of that, my lord, suppose there is a criminal case. That criminal case was not completed now. Suppose I have given the all benefit. In the meantime, I am criminally, my lord. They can again issue the order, my lord, DP, my lord.
Yes, Mr.
Other one case, but today I'm not taking that order also that given they complied with, my lord. That was not there, my lord.
Tomorrow, my lord, I will, that order also given. One, another order was same charges, my lord. The departmental proceeding and at the conclude last line, that is also there. They all are given, my lord, benefit, my lord. Pension, my lord.
Lordship, maybe please to issue notice, my lord, let us file an affidavit explaining the reasons, my lord. The honorable court will take a call.
If your lord, I'm praying before stay these two order, my lord. If your lordship allow me to go, then my lord, this order is a piece of paper, my lord.
We don't know.
Because now, my lord, the inquiry officers have been.
For the petitioner.
So, my lord, tomorrow, my lord, I am giving another order, my lord. That also, that line was there, my lord.
After 10 minutes. No. Plan your submissions before, not after.
Not, but there is a specific direction to complete the process.
Please look behind. How many people are standing there?
My lord.
If you wanted an adjournment, take it in the first blush. Not after we discuss, deal with the matter, we ask you questions and then you say, very conveniently, take it tomorrow.
No, I'm praying is that, no, my lord, your lordship is.
Submissions.
No, your lordship issue notice and in the meantime, my lord, that order may be stayed. Well, otherwise, my lord, this order is.
Saying it. Mr. and Bora and Krishna also heard Mr. And standing also for the finance department.
I appear for respondent 1 and 2, my lord.
1 and 2, Mr. D. Bora and Government Advocate appearing for number 3. And Mr. C. Bora and Barwag and correspondent number 3.
My lord, if your lordship is not passing an interim order, then my lord, whole repetition is infraction as well other order is also not in my
We
lord.
don't know, but we are not staying it. That's why we are asking you only one question I have asked.
My lord, my humble understanding is that line, my lord.
We'll take note of that. Don't worry. We will not take, it's not that we'll not deal with your submissions. By filing this repetition in Article 226 of the Constitution of India, the petitioner has stated for quashing of the show cause notice dated 9/8/2021 within bracket Annexure 12. Notification dated 19/9/2025 within bracket Annexure 21. For quashing of the impugned letter dated 4/9/2025 within bracket Annexure 19. And for directing the respondents to drop the departmental proceedings by exonerating him of all the charges. For directing the respondent authorities to raise the pensionary and other service benefits in compliance of the order dated 6/3/2025 passed in WPC 409 of 2023. And to direct the hearing officials to pay exemplary cost for defiance of the order dated 6/3/2025 passed in WPC 409 of 2023. Next. Issue notice written available on 27/10/2025. Requisite extra copies of the repetition which served on the Learned State and Department Council in the course of the day. Next, the Learned Council for the petitioner has prayed for an interim relief. And in support of the same, he has referred to the directions contained in paragraph 14 of the order dated 6/3/2025. Passed in WPC 409 of 2023. And it is submitted that as there is specific direction on expiry of 120 days from the date of submission of certified copy of the order, comma, the respondents shall finalize the pension of the petition within 4 weeks thereafter and release all his outstanding dues. So accordingly, it is submitted that the departmental proceedings have been initiated after 120 days from the date of receipt of a certified copy of the order, and therefore the proceedings of the departmental inquiry be state. Next panel. Having considered the operative directions contained in paragraph 14 of the order dated 6/3/2025, passed in WBC 409 of 2023, as the said order contains a directive that the finalization of pension being the requisite measure of having been made subject to outcome of the departmental of the judicial proceedings, comma, this court is unable to accept the contention made by the learned counsel for the petitioner that no further departmental proceeding could have been initiated or carried on beyond the period of 120 days. Next. In course of submissions, the learned counsel for the petitioner has submitted that in the meanwhile, the petitioner has already moved this court in contempt jurisdiction for non-finalization of his pension papers. Next one. As indicated above, the court is unable to construe the directions contained in paragraph 14 above of the order dated 6/3/2025, prohibiting the continuance of the department proceedings within beyond 122 days. The court is disinclined to stay for the proceedings, departmental proceedings. Next one. It is clarified that this order shall not be construed to have diluted the directions contained in paragraph 14 of the order dated 6/3/2025, requiring the pension of the petitioner to be dealt with in the manner as provided therein. Next, this Tom. 27/10/25.
Please, in the middle, not to affect any, my lord, otherwise, my lord, not to affect any, my lord, that order, my lord, by the petition.
Any adverse orders passed, any orders that may be passed in the matter will be subject to further directions to be passed in this petition.
Much good.
28. Item 28.
Yes, Mr. Dean.
In this case, my lord, petitioner, my lord, before your lordship, my lord, we agreed, my lord, in the new notification, my lord. 16/8/2024, my lord, that is page 57, my lord, Annex R8. Where, my lord, the recovery was done by the respondent authority, my lord.
This can hardware.
Yes, my lord, the action hardship, while, my lord, they were serving, my lord, 27 battalion. Yes, my lord, similar order, my lord, I have annexed, my lord. This notification was, my lord, for protection, my lord, my lord, without leave of the court, my lord. I have annexed on page 99, my lord, relevant page, my lord, page 104, my lord.
No, but let us issue a notice. We don't know what happens. 99.
99, my lord, same notification, my lord, this honorable court, my lord. Page 99, 104 is the relevant.
Okay, you want the same order?
Yes, sir.
Okay, I get it. Page 99. It will be same order. I thought this was disposing of the repetition, that's why. Without notice, we find it very difficult to dispose of repetitions. As far as Mr. A.K. Dattal and CDC appearing for the respondents. You are in SSB?
Lordship.
Okay, it's same order. Page 105. List along with. Last time would be list along with
1870.
WBC 1870 of 2025. Operative party 310, same one. Same period, March 19 to
Yes,
May
Lord.
22.
Same number.
Okay. Same. I've done such corrections.
Obliged.
Daily list item 18.
Yeah, please, Your Lordship. In this case, I filed an interlocutory application correcting some typographical errors. Matter may be adjourned for the day, Lordship. I have already filed an IA which is not in record, Lordship. Matter relates to the pension as well as other.
Seen that. Mr. ABT Hockland, counsel for the petitioner, submitted that he has filed an interlocutory application for correction of certain typographical errors in the writ petition.
In the cost title of the
In the
petition.
cost title of the petition. Let this matter be listed along with the said interlocutory applications.
Date may be fixed, Lordship. One second. Date may be
After the vacations, Your Lordship, because I just placed one instruction.
On 31/10/2025.
Demand, DC demand, which is what I get. Man for all the farmers. District ज़्यादा वो production and district ज़्यादा पर machine काम करो. ये बात है. आपसे लोग अच्छो.
Okay.
Some time will be done.
We're fixing it on 29, 31/10. 31/10 along with the said interlocutory application.
Obliged.
19.
Respondent number 4 in 19.
18.
This is 19. Also, in this case, I'm appearing for respondent number 2, 3, and 4, my lord.
Yes, you are ready with money?
We are supposed to file the affidavit, and today we couldn't.
Forget about the affidavit. Are you ready with money?
But there are some issues. That's why the money has been not yet paid, my lord. Let the affidavit come, my lord. The affidavit is ready, and we are supposed to file it today itself. But I couldn't locate my friend, my lord. That's why it could not be filed today. I'll serve the copy today itself, my lord.
Yeah, you couldn't locate Mr. Datta.
Yes, we have served the
It's
copy
okay.
right now.
Normally we find him, always find him.
In fact, he was
It's
called.
okay. It's okay, but
Let it fix immediately after vacation, my lord.
and this says Datta and counsel for the petitioner. Mr. Rajshekar, counsel for respondent number
2, 3, and 4, my lord.
2, 3, and 4. Raised for some time, has submitted that he has received instruction and will be filing an affidavit.
We are filing it tomorrow, my lord, because today's time is already over.
He's filing by the next working day. Who was present?
She was in item earlier already.
Acha. I am for the earlier case. Okay. I forgot her name.
She was telling that she was referring for respondent number 4, my lord, in the earlier matter.
Very correspondent of who? But I
Respondent
forgot her name.
That I know.
Well, I'll collect and I'll give the court master.
Her name, respondent in the other case. Yes, your name I forgot. I forgot your name. I answered. Okay. And who's for respondent number 1?
I'm
You'll be
waiting
there.
for 1 year.
Mr. P. Rajput, and it's, but we counsel for respondent number 1. So it's the Corporation Department, respondent number 1. Then it's counsel for respondent number 2 to 4 is submitted that is filing affidavit in opposition. By the next working day, accordingly, matters stands on today. This again on 24/10/2025.
Item 20.
Highly obliged, my lord.
Lordship, in this case, Lordship,
Yes.
My lord, the petitioner for lordship was placed under suspension, my lord,
They have,
on 28/6/2024, my lord. More than 1 year have passed.
but council has taken a decision in the meantime, 12 July 2024.
My lord, he was placed under suspension for a period of 6 months. That 6-month period is over. That 6-month period is over, my lord, in the month of January.
Yes.
So, my lord, now he can practice. But the impugn order, Lordship will find at page 21. I have been placed under suspension on 28/6/2024. More than 1 year has passed, no review, my lord. Mandatory review is within a period of 3 months. Thereafter, they can review within 6 months. That is the, my lord, requirement, but no review. And my lord, the last paragraph, Lordship will kindly notice, during the period in which this suspension order shall remain in force, the headquarters of Dr. Miduvanath shall be Difu, and he is directed not to leave this headquarters without obtaining written permission. And my lord, the last but one paragraph, my lord, barred from carrying out private practice or any other employment, business, profession, vocation. My lord, he has not been paid any subsistence allowance. No, my lord, all the bank accounts has been seized. My lord, how he will survive, my lord? That is the only difficulty in my part, my lord. He's a doctor, my lord. He has been barred from practicing, though his suspension period is over. At least, my lord, he should be allowed to practice, my lord, even if he is not reinstated.
my affidavit is ready. Just, I have received this after
No,
signing.
but if you have not reviewed his suspension,
Lordship, January 7th, second review was done.
second review.
Second review, yes, Lordship. And then he was in jail for 1.5 months, maybe. I don't know, but in February, he was arrested by the vigilance. Then he released, he may be released.
He
He
may
may
released.
be released. Then, therefore, Lordship, I have prepared a
But
detailed
to
affidavit,
release his,
Lordship.
suspension allowance, subsistence allowance will have to release.
Lordship,
That has not been released, my lord.
one prayer on Lordship. Reopening day, 14th. Lordship may give final order. At least I have to file this affidavit by
No, you
tomorrow.
did it, but in the meantime, you want to process that subsistence allowance. That can't be withheld. In the meantime,
That-
if you have suspension, the subsistence allowance will have to be.
Yes.
Or, my lord, I may be allowed to practice, my lord, or I may be allowed to
Now,
practice.
there are so many allegations against this
Whatever it is,
doctor.
but if you are not
Ex-
allowing him. in the
There are so
meantime-
many allegations, Lordship. There
It's
are
okay.
so many allegations.
Well, he may be worse man on the earth.
Yes.
Yes,
But subsistence allowance has to be paid.
yes,
This is
yes.
your requirement. You process that in the meantime.
Process means, Lordship, giving direction for process.
Yes.
Yes.
Heard. So I S Agarikar and I had Saiki and Council with Petitioner. As well as this is S. Sharma and it's standing also for the health department.
Responded to
Appearing for all the respondents.
two.
for the respondent two. And Mr. D. Boral and the government advocate appears to respond to one. Next, brother. The continued suspension of the petitioner is assailed by the petitioner by filing this petition under Article 226 of the Constitution of India, along with prayer for setting aside the suspension order dated 28/6/22 and for his reinstatement in service along with area pay and other benefit, other service benefits and consequential service benefits. Next, the Learned Counsel for the petitioner has submitted that he is also debarred from the petitioner is a medical practitioner and he's been debarred from doing private practice. Should notice returnable. Notice has not been issued.
Notice.
Notice was not.
Oh, issued.
Issued.
Notice was issued.
You said the notice not required is issued. The learned standing also for the health department submitted that she has received Parava's comment and will be filing an affidavit.
No,
In the
not,
matter?
sorry, Lordship, affidavit is ready to file, so tomorrow we will file it.
The affidavit is ready for filing by the next working day. And accordingly, she prays for an adjournment, next para. Taking into consideration that the petitioner is in continued suspension since
Since, my lord, 28/6/2024.
comma, by the next date of listing, comma, the respondent notice shall, the respondent too shall inform the court as to whether any steps has been taken in the meantime for payment of subsistence allowance to the petitioner during the suspension period. Next paragraph, the learned standing counsel to the respondent shall send a downloaded copy of this order to the respondent two, just to enable him to do the needful and to process the requirement of payment of subsistence allowance, comma, if not already processed. Next paragraph, list on 15/10/2025.
23rd, my lord. That week I will not be available, my lord. On 23rd, my lord.
23rd you want.
My lord.
23rd is a hearing date. We can make it
24th, 24th, my lord.
24/10/2025. Just send the downloaded copy of the order. Here,
Lordship,
please.
I'll do.
Oblige, my lord.
21.
May it please your lordship. In this matter, my lord, I have received some instruction, my lord. I will file affidavit, my lord.
Miss
A Biani,
A.
Biani.
Yes, for the petitioner. MD Bora.
Lordship, for transport.
Standing counsel for the transport department submit that she has received instructions and would be filing an affidavit in opposition in the matter. Next one.
Your Lordship, a date may be fixed.
Matters was adjourned today. List,
Your Lordship, first week of November.
you want first week,
Yes, Your Lordship.
list on 3/11/2025.
Okay, Your Lordship.
Obliged, lord.
Much obliged, Your Lordship.
Yes, 29.
29.
May I please, Your Lordship? In this is Stanley Perus, the last order of office.
You see that.
There is a petitioner is suffering from cancer, he is not in a position to.
Yes, government advocate, Mrs. Bhattacharya. What you fear for, an accountant general,
Mr. D. Gugoi, the standing counsel for
Forest is the only party, government is not a party.
No, accountant general is also there.
Like,
He is
that-
requiring the release of leave encashment, gratuity and group insurance. So maybe you have to release this payment order for leave encashment, gratuity. This is suffering from cancer.
Lordship, today you have received the instruction, we are filing, we'll file tomorrow, the affidavits. Affidavits are ready, we are filing it tomorrow.
No,
Your
no,
Lordship.
but as per your instruction, you are getting it, you are releasing it or not releasing it.
That's in, that we have placed before, in the affidavit, Lordship, because we have already given an amount, Your Lordship, which is nearly about 90 lakhs. We've already given him. His provisional pension, we have paid, everything we have paid. The statements, let the affidavit come on record, Your Lordship, that we have everything, Your Lordship.
You have paid. You see, the requirement is that, you see, in the last order, we have recorded that the petitioner claimed that he's suffering from cancer.
And his proposal for regulation 402 days, Your Lordship, especially has been sent to the higher authority, Your Lordship. An amount of 82 lakhs 52,000 and 5 lakh 96,000 have already been released to him, Your Lordship.
82 lakh.
82 lakhs 52,688 and 5 lakhs 96,246.
Okay, then we can adjourn it. If you have received 82 lakh. In the meantime,
Immediate after vacation.
and Mr. A.B.D. Rock, Learned Counsel for the petitioner, is referred to the earlier order dated 22/9/2025. Next order. Mr. R. Goel, and that's time for the Forest Department has submitted that he has received instructions and will be filing an affidavit. In the matter.
HE5.
He has also submitted that as per his instruction, a substantial amount of money has already been released to the petitioner. List the matter on 17/10/2025. Affidavit should be filed 2 days prior to the next date of this.
Very well, Lordship.
I'm for it. You are for? Respond of 5. Yes. Let's ask him to respond of 5.
30.
Lordship, in this matter, we'll seek for the original records in original, Lordship. So we'll receive that. Let the matter come after vacation, Lordship. Records in original, Lordship.
You file your affidavit in the matter?
Well, Lordship, as well as we'll produce our old records. from it.
The ABT of the counsel with the petitioner is present. Our
Excise Department.
Mr. R. Goel and standing for the Forest Department.
Excise Department.
Excise Department. Submits that he has received instructions and will be filing an affidavit in the matter.
Lordship,
Also
instructions are
produce the
awaited.
records. Next, Mr. D. Boral, and government advocate is also present. Matter since adjourned today, list again on 17/10/2025. So then we shall be filed at least 2 days prior to the next date of this time.
31.
May I please, Your Lordship? Your Lordship, hearing the petitioner, Your Lordship, retired on 30/11/2024. Your Lordship, as Secretary to the Government of Agriculture Department. There is a department of proceeding pending, Your Lordship. Now, as per Rule 22(1), Your Lordship, I am entitled for provisional pension and other due retirement benefit. No any retirement benefit has yet been paid, Your Lordship, till 10 months has already been elapsed. And moreover, Your Lordship, may kindly see and accept her medical condition.
Yes, okay.
36, she is suffering from thalassemia and grade 4 liver cirrhosis, Your Lordship. Thalassemia is very expensive treatment. Regular transfusion of blood is required.
Yes.
Your Lordship.
Lordship, we have certain instruction, Lordship. She is not governed under the Assam Service Pension Rule, Lordship. So she is governed by the Central Civil Service Pension Rule, Lordship, because she retired as IAS officer, Lordship. So she has to fill up certain forms, Lordship, to process the pension, Lordship, which she has not done, and no averment on this regard, they have fulfilled all these conditions, Lordship.
No, you see.
They, then,
He's a retired government servant.
yes, Your Lordship. DP is going on, the personal secretary to the personal department had issued show cause notice, I have replied, your lordship. They could have communicated, now 10 months has elapsed. How they can say make this submission, whatever rule is applicable, let them
No,
proceed.
you said, please don't accuse the learned counsel
Your
of
lordship.
how she is making that submission. She is making submission as per the record.
Yes, your lordship,
You want a solution, you don't want a confrontation.
I want solution, your lordship,
Then-
not confrontation.
Confront with the assistant senior commander, she is assisting the court.
I'm sorry, your lordship, I am making submission because I am suffering.
Let's
10
employ
months.
this lordship and within a short time, I will, that means communicate them to process this at the earliest lordship.
At
On
least-
fulfillment of the conditions lordship.
At least my retirement benefit, GPF, that can be released, your lordship. It is my
No, no,
money.
please try to understand what she is saying.
Yes, I know.
She says that you are not covered.
Governed by
Assam
that rules.
So you'll have to make a compliance. That's what she's asking.
Yes, that can be done for release of pension. But regarding the provident
Everything,
fund,
lordship, everything.
no, provident fund, yes, that can be released, your lordship.
Please understand her submission.
Yes.
If you are really interested in confrontation, we'll permit you that. But she's giving you a solution that it is covered by the requirement rules for the IAS officers.
Yes, I
They have
agree,
to
your
fill up
lordship.
Form 8 because it can't be that for one purpose you will be governed by the Assam rules and for one part you will be governed by the IAS rules.
No, I will govern by that rules, your lordship. I am not on that.
Then
But for the purpose of release of
she can't
GPF,
process. That can't be processed. That's why we are saying you don't want a negative order.
can observe, I will fulfill.
We are permitting you.
What-
Since you have said that you are ill, we are permitting it.
Yes, what documents I have to request that maybe I will.
Make it in the order. She has made
Yes.
this.
Let me rephrase, your lordship. I am obliged to that.
Mr.
observation.
Mazumdar and counsel for the petitioner. He has submitted that the petitioner has superannuated on
30/11, 2024.
2024 while serving as
Secretary to the
Secretary to the
government.
government of Assam from Agriculture Department. First off, it is submitted that before that before her retirement, by the notification dated 1/6/2023, the petitioner was put under suspension by with effect from 18/3/2023. Which is followed by memorandum of charges, which is stated to have been contested by the petitioner. The learned counsel for the petitioner has secreted. The petitioner is suffering from
Page 37.
grade 3 liver cirrhosis, from hypertension and diabetes. And therefore she urgently requires money for her treatment. Stop. Accordingly, it is submitted that pending the departmental proceedings, the provisional pension is required to be released of the petitioner. Next paragraph. The additional senior government advocate has submitted that she has received instructions by letter dated 4/9/2025, wherein it has been indicated that the
Instruction.
petitioner was initially an Assam Civil Service employee and thereafter promoted to IAS cadre. And accordingly, the final pension and other retirement benefits, including the provisional pension, is required to be processed as an IAS officer by duly filling up Form 8, Form 3 numerical, Form 5 and Form 7, along with all other relevant documents as required under the Central Civil Services Pension Rules from 1972. Civil Service, not as services, Service Pension Rules 1972, which is required to be submitted by the petitioner. Stop. In this regard, it is further submitted that as per her instructions, the Department of Personnel, within bracket, Personnel A, bracket, Government of Assam, has not received any proposal from the petitioner regarding sanction of pension of the provisional pension in date. Where is your application?
Lordship,
Where is your application for provisional pension?
provision pension here, no application here.
No application, Lordship, nothing.
Okay. Next one. Accordingly, the court is inclined to provide that as the learned additional senior government advocate has spelled out the requirement of compliance by the petitioner or by submitting the requisite form numbers, forms as referred above, along with all supporting documents, or the court is inclined to provide that the petitioner shall make an application for provisional pension before the authorities competent to grant, but process the same, and also submit the hearing before referred forms and submit the same along with all relevant documents as required under the Central Civil Services, the Service Pension Rule for 1972 to disclose of next para. In view of the projection by the petitioner that she is unwell, requiring treatment, the court is of the considered view that in the event there is some deficiencies on part of the petitioner to fill up the forms and applications, the concerned officials of the Department of Personnel, within bracket Personnel A, Government of Assam, receipt of the application by the petitioner, shall inform the petitioner about the shortcomings or deficiencies in the application by an email, for which the petitioner shall also provide email address to the concerned authorities before whom the application for provisional pension is made. Next para. The petitioner, along with her application and these duly filled up forms, shall also produce a certified copy of the order so as to enable the concerned authorities in the Personnel A department to process the prayer expeditiously. Next para. In the meantime, the learned additional senior government advocate shall also transmit a downloaded copy of this order to the concerned authorities to put them into advance notice for processing the prayer for release of provisional pension pending the departmental proceedings.
Lordship.
For Easy one, accountant. For accountant, Mr. Committee, as signing of the 18th. We find out a solution for
Yes, dispose of your lordship.
No, we are keeping it pending.
Your lordship, one thing I made, your lordship will permit, provisional pension and other due retirement benefit.
Other admissible dues.
Admissible,
Admissible.
yes.
Okay.
Problem, much obliged, your lordship.
Deeply obliged.
These are few government advocates on whom we can rely, as we always do. So therefore, you know that they will always help you.
Definitely, so she will definitely help me. I know.
Because at least in my courtroom, I can say, not about others, but in my courtroom, I have never lacked any support from the government advocates.
I am also obliged to her.
It is our duty, lordship.
No, it's not that, but at least I have found every support from every government advocate. I have not found it lacking from the treasury side.
I will immediately make an application.
Even if it is not there, but they make an effort, because at least all this time I have never found
Yes.
lack of support from, and prompt, not support, in fact, prompt response from them. That's why.
Much obliged.
Let me visit.
I will make an,
please,
your lordship,
please meet me.
your lordship, I will make an application and they will consider within some certain time.
Yes,
period.
lordship.
We have not said, we process it.
Some time.
We are
Yes,
fixing it
lordship.
on.
Only because I am
Yes.
making this submission because
Okay.
she is
Then-
seriously ill, perhaps she will,
No, it's
may not survive, your lord.
It's okay.
Liver cirrhosis, thalassemia is
Process, you just say, application made shall be processed expeditiously. List on 30,
October.
May 29/10.
Lordship.
Much obliged, much.
Deeply obliged. No, this is. They have to wait over. And we have our environment daily.
Itu Kumar.